May please.
Yeah.
Lord, the main issue in these cases, the appointment of the members of the election commission.
That's right.
Now, Lord, we have prepared a written note, which I am just handing.
Compilation.
Compilation is there of all the documents. This is a written note of submission.
That's right.
That's not there in the compilation. I'm just handing it over. We can send it across. Copy. If I might just take your lordship through this written note.
Yeah. Just one number. Well, there are three petitions before your lordships. Mr. Bhushan and Mr. Chaudhary will address your lordships on the main issue regarding appointments. I will supplement on that issue. I'm in a separate petition which is also here, but there are three additional smaller issues which I will address them.
Requested that as soon as Mr.
Lawyers.
I'm supplementing his petition. I will not.
That's right. Only request we can make it. The arguments which are made, you just adopt your, I mean, you will not repeat. We don't have to tell you that, but just, we just remind you. So
Yes,
it's safe
but,
time.
I think Mr. Ashwini Upadhyay was larger issue, not that way.
Whatever is.
We are confining only to the appointments.
Okay.
So that's why my request was, as soon as Mr. Prashant Bhushan finishes, I'm just below Mr. Ashwini Upadhyay's
So
petition.
just tell us how many repetitions are before us?
Four are,
Total of 4.
Two are almost identical. That is
one and three.
One
Just give us the numbers, repetition number.
Anup Baranwal, which is
The first one.
104,
Okay.
and ADR,
That is 104 of 15
yes,
is similar to.
similar to 569 of 21. The only difference is that in 569 of 21, we were constrained to move this, Lord, because there is a vacancy which exists till today in the election commission. And we were also seeking an interim order saying that at least that vacancy should be filled up by an independent body, not just by the government.
I am in 104. Petition 1043 of 2017, that's Ashwini Upadhyay. And Mr. Chaudhary, I think, is in Jaya Thakur.
Yes, number 5, Dr. Jaya Thakur.
998 of 2020.
What about repetition 1043? That is by you.
That's fine.
That is Ashwini.
Yes. So first and third, Mr. Bhushan. Second, me. Fourth, Mr. Chaudhary.
Oh.
But we'll go with Mr. Bhushan, then Mr. Chaudhary, then me.
Out.
Mr. Bhushan is pressing for your application for amendment.
No, that amendment was allowed long ago. That amendment was allowed long ago. There is an amended petition before the vote.
Amended petition is it part of this compilation or
Pleadings are not part of the compilation. Pleadings are not part of the
where
compilation.
is the amended?
It's a me.
Already amended,
Yes, already. Already amended, amendment was.
incorporated.
Yes.
Yes.
So, my Lord, to give your lordships
Yours is.
an overview,
And this book is.
actually let me proceed along a note that I have just handed over.
Yeah.
I'll pick up from.
As your lordship is aware that election commission is a body charged with conducting free and fair elections, which are certainly essential for democracy, which is a basic feature of the constitution. There is no dispute about it. Election commission has a number of very, very important powers, such as we have mentioned, my lord, what are the powers that the election commission enjoys. It has the power to register political parties at page 4 of this note. It has the power to recognize political parties and allot symbols. It has the power to take decisions regarding splintered or rival groups arising within already recognized parties. This is one of the matters regarding Shiv Sena, which is currently before this court also. It has also the power to suspend or withdraw recognition of recognized political parties for failure to observe model code of conduct. It has also the power to enforce model code of conduct, in banning candidates from campaigning during elections, removing star campaigners from elections, etc. So it has complete and total powers regarding conduct of elections in this country. It has from Shamsher Singh onwards, my lord, large number of decisions. Now the question is, can such a body, the article in the constitution which deals with the appointment is 324(2). It says appointment of the Chief Election Commissioner and election commissioners shall be made by the President, subject to any law made by Parliament. It says Election Commission shall consist of the Chief Election Commission and such other election commissioners, if any, as the President may from time to time fix, and the appointment of the CEC and other election commissioners shall, subject to the provisions of any law made on this behalf by Parliament, be made by the President. So unfortunately, my lord, when the Constituent Assembly debates took place, Dr. Ambedkar said that, look, we expect Parliament to make a law to provide for some kind of independent selection of these election commissioners. But unfortunately, my lord, we are now 70 years down the line, 71 years since the Constitution was made, or 72 years since the Constitution was made. No law has been made by Parliament till today to regulate the appointment of the election commissioners, and it continues to remain in the hands of the government. Now, my lord, the factual situation is that till the time that Mr. Session was appointed election commissioner, the election commission's independence was seriously in question. After Mr. Session, there was a long period where, for one reason or another, Mr. Session set the tone and the election commission behaved fairly independently for many years thereafter. But unfortunately, today it is no longer the case for the last several years. And these doubts about the independence of the election commission have been recognized by a citizens' commission, which was headed by Justice Lokur, who said that today the independence of the election commission is seriously in question. Now, it was thought initially that maybe perhaps the mere fact that the election commission, that the functioning of the election commission is not controlled by the government, and that the election commissioners cannot be removed by the government, except by following a fairly stringent procedure. In fact, not the removal is through
Impeachment
impeachment.
of the Supreme Court judge.
Yes, just like Supreme Court judge. But unfortunately, my lord, that by itself is not enough to ensure that the election commission functions independently. That is just functional independence. True that the election commission does enjoy functional independence in that sense. But if the appointment, and that was recognized in the judge's case and several judgments in the cases relating to appointment of judges by this court, starting with Spora, thereafter with the NJAC commission, that just functional independence by way of ensuring that the removal cannot be made by the government, or government does not enjoy disciplinary powers, is not enough to secure the independence of the judiciary. If the appointment remains completely in the hands of the government, then that itself,
Mr. Bhushan,
yes, please.
we are not examining the ground realities
Yes.
or the individual's perception.
Yes, we are not.
We are examining the procedure being followed
Yes.
in making an appointment. whether it is in conformity with the constitutional mandate or not.
Right.
And if not, according to you, what are your suggestions
Yes.
to make the better system transparent and the people's faith,
Yes.
which is the
Your lordship is right. We are not-
predominant.
That's why
I
we
want to know from you, what is the mechanism as on today in implementing 324.2, and what is the mechanism which you suggest to us
So, my
in
lord,
addition to it?
so I would have come to this question. Your lordship has put it right in the beginning. So let me state it right up front. So there are 5 commissions which have gone, appointed by the government, which have gone into this issue as to what should be the method of selecting and appointing election commissioners. The last one being the Law Commission in 2015. So the Law Commission recommended a procedure similar to the procedure currently in place for appointment of the CBI director. That is, Prime Minister, a committee consisting of Prime Minister, Leader of Opposition, and the Chief Justice of India. This is in my respectful submission, my lord, that's my alternative suggestion, though in my note I have not written that. Because one of the things which agitated this court in the judges appointment case, especially in the NJAC case, where NJAC was declared to be unconstitutional and violative of the basic structure, was if you have a system where the government also plays a role and the judiciary also plays a role in the selection of judges, that means they jointly decide the selection of judges. Then they said that there is a possibility and a fear of give and take happening between the government and the judiciary, which is also not good for the independence of the judiciary. So they said that government should be totally removed. The only power that the government should have is to send the name back once. Thereafter, if it is unanimously reiterated by the collegium, then the government has to appoint that judge. Because there should not be any give and take between the government and the judiciary regarding appointment of judges. Now, and the basis for that was that the government is the main litigant in the judiciary or major litigant in the judiciary. Government has a stake in so many cases, especially cases involving protection of fundamental rights of citizens. And therefore, being one of the main stakeholders, it should not play any significant role or any role in the selection of judges who are going to be deciding these disputes which involve the government as a major party. Same thing I would suggest, my lord, so far as Election Commission is concerned. Of course, my default suggestion would be to follow what the Law Commission has said. That is, Prime Minister, Leader of Opposition, Chief Justice. But my first suggestion in my respectful submission is both the Prime Minister and the Leader of Opposition being heading political parties which are key players in the election process, ideally should not have a say in the selection of election commissioners, because election commission is the body which is going to decide not only disputes between the government and the opposition, etc., but is going to play such a critical role where the interests of the ruling party and the opposition are directly involved. Therefore, in my respectful submission, my lord, the selection should be by a body which is totally neutral. So such a body could be the Collegium of the Supreme Court. This is one possibility. The other possibility is that you say Chief Justice of India. You can add the present Chief Election Commissioner, because outgoing chief or the existing, if a selection of a member of the election commission, then the present chief election commissioner. You can add perhaps chairman of Human Rights Commission or somebody like that. You can add perhaps, I'm not saying, my lord, what the situation is today. I'm saying that ideally, it should be, the selection should be in the hands of a body which is totally neutral. And though today, because the Election Commission is being appointed by the government, today the Comptroller and Auditor General is also being appointed by the government alone. Yet, both Election Commission and CAG at least have functional independence. That means they cannot be removed by the government at their own sweet will. So in my respectful submission, there are these two kinds of bodies which will be totally neutral. One is the Collegium of the Supreme Court, which is the same collegium which selects judges. No, because it has to be a neutral body. What I am respectfully submitting is, my lord, the recommendations.
Keep one thing in mind,
Yes, sir.
and we can share our experience.
Yes, yes,
Wherever there is a human discretion
yes.
element is there, discretion element. By and large, our experience also shows.
Yes.
Now, the only thing which we visualize from you is how this human element discretion
Yes.
available can be minimized. That only reflects your transparency. Because the discretion exercise, you have to keep the faith over the people who are manning. Ultimately, like we people in our judiciary, we take action against our judicial officers, and the same very judges who are party to those minutes and who have reported their signatory to take action against him, tomorrow sit in the judicial side and set aside the orders. Transparency is there, but still human element is
So
there.
your lordship is right that
And once we come out with the doctrine of necessity, somewhere down the line we have to show our trust over the persons who are manning the posts, and this discretion has to be exercised.
so, my lord, here there is no doctrine of necessity in the present system because the selection is totally by the government, only by the government. Nobody else plays any role, and the government is clearly a partisan player in the matter, in all the matters which the Election Commission decides. Because the government is heading a political party which is a key player in the conduct of contesting elections. So therefore, on the principles laid down in the judges' appointment cases, as well as there have been several cases, my lord, where your lordship have directed, even for CBI director, it was this court's direction which eventually led to that in Vineet Narayan. In police chiefs,
Yes.
yes, my lord.
This suggestion or submission is for the, meant for the time during which there is no law made by parliament, or you want to assume
Higher
court.
higher status. I want, Lord, your lordship to lay down, because it should not be that tomorrow the parliament makes a law. Suppose today the court directs that the selection of the election commission should be whatever. Suppose the court says, all right, Prime Minister, as the law commission has recommended, Prime Minister, leader of opposition, Chief Justice. And thereafter the government brings a law saying that no, it will be by the government. It will be a much worse situation than the NJSC Act. In the NJSC Act, the only role of the government was that in the selection committee there was a law minister and there were two other people, jurists, who would be selected between the government and the Chief Justice, etc. And that the Secretariat would be housed in the Law Ministry.
But judges' appointment is the provision in the constitution, there was a consultation which we have interpreted over a period of time.
Yes, yes.
Here there is a specific mandate of the constitution that parliament by law can make this
Yes, Lord.
appointment. Now,
That is true.
how do you want us to confer on ourselves a jurisdiction to read down
What I
that
would-
part of Article 24(2)?
Yes, Lord. What
In that
I,
regard, one more,
yes,
see, 324(2), it says for appointment of the chief election commissioner and other election commissioners shall,
yes,
subject to the provision of any law made in that behalf by the parliament.
yes.
And now in the unamended petition, you sought for issuance of a mandates.
Yes.
Now, of course, you are seeking issuance of any appropriate direction. To what extent you are saying that this court can issue a specific direction to make a law in a particular manner?
No, we are not saying that make a law. We are,
In the light of the directions, the prayer, that is what
I
we
am
are.
not seeking that.
Of course, 324(2), it says
I'm not asking for a law to be made, my lord.
prayer. That is why.
Maybe, my lord, that
Yes.
may have been. written.
Because the prayer, see, the amended prayer, of course, mandamus was the, originally it was sought for. Now, in the amended petition, you sought for another prayer, issue an appropriate order or direction
Yes,
to respond to implement an independent and transparent system.
so that's why, my lord, the original writ petition was not filed by me. When the petitioner came to me, I told him that you can't seek a direction to Parliament to make a law. So therefore, my lord, I sought permission to amend the petition, permission
And
was
instead
granted.
of that, now you are using the expression implement.
No, we are saying respondents to issue a writ, order or direction to the respondents to implement an independent and transparent system for appointment of members on the election commission on the lines recommended by these various commissions. 4, 5 commissions, 5 commissions which went into it. But I am now today, my lord, in my oral submissions going one step further. I am saying that these commissions recommended a selection committee consisting broadly Prime Minister, Leader of Opposition, all of them say. In addition, there is some difference. Some of them say Chief Justice, some of them say
That's
some
what speaks.
Speaker, etc. I am going one step further in line with the NJSC judgment. The NJSC judgment says that, look, this system where the main stakeholders also play a role in selection of judges, though the dominant people may be independent, but if the main stakeholders also play a role, then that will be amenable to give and take, which is not good for the independence of the judiciary. I am saying the same thing with regard to the Election Commission. Today, my lord, Election Commission, the main political parties are the main stakeholders before the Election Commission. They are the main stakeholders. And therefore, in my respectful submission, the system should be selection by a totally neutral body. Now, what that neutral body could be, I have said. One option is the Collegium of the Supreme Court, just as they select judges. The second option is that you can have 3 senior judges of the Supreme Court, along with, let's say, the existing Chief Election Commissioner, the Chairman of NHRC, or the CAG. I am mentioning these authorities because at least they enjoy functional independence. Tomorrow, my lord, after your lordship's direction in this case, assuming that we succeed, the election commissioners will also enjoy independence by way of selection. And once that happens, then of course, my lord, the chief election commissioner can certainly be in the selection committee, or the outgoing chief election commissioner, if this selection is of the chief election commissioner, certainly be on the. So therefore, my lord, this would be, in my respectful submission, a neutral body where the main stakeholders do not play any significant role. And that will ensure. The argument is this, my lord. Free and fair elections is a basic feature of the Constitution. Democracy, basic feature of the Constitution. Now, if it is felt by this court, which has plenary powers under 142, that in order to ensure the independence of the election commission, it needs to be selected by some independent body, then, my lord, this court has in so many cases given such directions. In the case of police reforms, Prakash Singh; in the case of CBI reforms, Vineet Narayan; in the case of judiciary, Skora; in the case of electoral reforms, that ADR and that PUCL cases, where the court said that, well, in order to have free and fair elections, we need to know the criminal antecedents of candidates. It was not there in any law. But the court said that it is necessary in order to have free and fair elections and transparency in elections, that the candidates' educational qualifications, his criminal antecedents, his assets and liabilities must be known to the people. And therefore the court gave directions, gave binding directions that, look, Election Commission must ensure that this information is obtained on affidavit from all the candidates. Thereafter, the government tried to override that by passing a law saying that, no, this is not required. And that law was struck down in the POCL case as being inconsistent with free and fair elections. So I am saying, my lord, the directions to be issued by this court should not be overridden tomorrow by a law passed by Parliament. Tomorrow they can pass a law saying that, well, government will enjoy complete control over the selection. But that should not override, because these directions are being given to implement the basic structure of the Constitution, to implement the basic feature of the Constitution, which is free and fair elections.
Yes.
Now, my lord, so I have given the end of what I want. Now, my lord, let me take your lordship through the material. So, first, what happened in the Constituent Assembly? So, my lord, Dr. Ambedkar, at page 2 of the note, your lordship can just take the note because I have quoted almost.
You've seen it actually. You've seen the line of argument in the material.
Yes.
So Bangla, Saxena, the exchange
Yes.
between them,
Yes.
and then what are Dr. Ambedkar. So you've seen that.
So, should I read it, or I don't know whether.
You've seen it. Go ahead in your room.
That's very good. So,
Yes. Go ahead.
yes, sir. But page 2 of the note, my lord, Dr. Ambedkar presented an amendment in Article 289(10) of the Constitution, of the proposed Constitution. The amendment vis-a-vis the appointment of Election Commissioner was as follows. The Election Commission shall consist of the Chief Election Commissioner and such other election commissioners, if any, as the President may from time to time appoint, and when other election commissioner is so appointed, Chief Election Commissioner shall act as chairman of the commission. Dr. Ambedkar, while presenting the amendment, said the House will remember that in a very early stage of the proceedings before the Constituent Assembly, a committee was appointed to deal with what are called fundamental rights. The committee made a report that it should be recognized that the independence of the elections and the avoidance of any interference by the executive in the elections to the legislature should be regarded as a fundamental right and provided for in the chapter dealing with fundamental rights. When the matter came up before the House, it was the wish of the House that while there was no objection to with regard to this matter as of fundamental importance, it should be provided for in some other part of the Constitution and not in the chapter dealing with fundamental rights. But the House affirmed without any kind of dissent that in the interests of purity and freedom of elections to the legislative bodies, it was of the utmost importance that they should be freed from any kind of interference from the executive of the day. In pursuance of the decision of the House, the drafting committee removed this question from the category of fundamental rights and put it in a separate part containing articles 289, 290 and so on. Therefore, so far as the fundamental question is concerned that the election machinery should be outside the control of the government, there has been no dispute. What Article 289 does is to carry out that part of the decision of the Constituent Assembly. It transfers superintendence, direction and control of the preparation of electoral rolls and of all elections to Parliament and the legislatures of the states to a body outside the executive to be called the Election Commission. This is the provision contained in subclause 1. Then, my lord, Dr. Shibban Lal Saxena raised reservations about the appointment of the Election Commission by the President and proposed that Election Commission should be appointed by 2/3 majority of both houses so that the Commission enjoys the confidence of the House and not only of one party. That is at page 33-34 of the compilation. Dr. Ambedkar addressed the criticism of Mr. Saxena and conceded that his provision, that is appointment of Election Commission by President, does not contain anything to provide against nomination of an unfit person to the post of Chief Election Commissioner or any other election commissioners. In order to overcome the objections of Dr. Saxena, Dr. Ambedkar added, subject to the law made by Parliament in draft Article 289, observing, quote, because, as I said, it is going to be one of your greatest headaches, and as a via media, it was thought that if this assembly would give or enact what is called an instrument of instructions to the President and provide therein some machinery, which it would be obligatory on the President to consult before making any appointment, I think the difficulties which are felt as resulting from the American Constitution may be obviated and the advantage which is contained therein may be secured. At this stage, it is impossible for me to see or anticipate what attitude this House will take when the particular draft instructions come before this House. If the House rejects the proposal of the drafting committee that there should be an instrument of instructions to the President which might include, among other things, a provision with regard to the making of appointments, this problem would then be solved by that method. But as I said, it is quite difficult for me to anticipate what may happen. And therefore, my lord, the final provision which came was as it presently stands, that subject to any law made by Parliament. Unfortunately, no law was ever made by Parliament. Then, my lord, I have mentioned the powers of the Election Commission, that they enjoy vast powers of all kinds. And of course, this court has also held in Shamsher Singh onwards that Election Commission's powers are vast. They have complete powers to control free and fair elections, to ensure that elections on all matters. Therefore, mentioned provisions show that the power of the Election Commission extends to resolving disputes between various parties or adjudicating on a complaint made by one party against the other party. So the parties are stakeholders. The Election Commission play even a quasi-judicial role or a judicial role in determining disputes between political parties, which are headed by the Prime Minister, Leader of Opposition, etc. Then, my lord, I have not mentioned it, your lordship may just note that there was a Citizens Commission, here your lordship may note, headed by Justice Lokur, which is at page 999 of the compilation, where the Citizens Commission, this is of last year only, they have mentioned that the Election Commission unfortunately is no longer functioning very independently. I don't want to get into that. I don't need to get into that. I'm just saying, my lord, if the situation had been what was prevailing when in the time of Mr. Session or some years thereafter, this matter would not have assumed the kind of importance that it has today. Today, unfortunately, because there are, I'm not saying, I'm not even getting into the question whether the Election Commission has been behaving independently or not, but certainly a lot of people, a lot of very respectable people have voiced apprehensions on this, that the Election Commission is no longer behaving very independently. So therefore, dates are being announced at the dates for elections are being announced, which are known and announced by the government or the party in power prior to the election commission announcing the dates and so on. And all kinds of things have been happening. But it is not necessary for this court to go into that. It's enough for this court to say that, look, election commission's independence must be secured. At all costs, the independence of the election commission must be secured. And in order to secure the independence of the election commission, it is not enough for the election commission to have functional independence by way of government not having disciplinary control over them. It is also necessary that the selection of the election commission is by an independent body or by a neutral body, or certainly not controlled just by the government alone. So because government is certainly one of the stakeholders, it can't be. Thereafter, my lord, there are reports of various commissions which I have mentioned.
Goswami Commission.
Yes, first is I have mentioned the Law Commission. They recommended, and this is at page 266.
Goswami Commission proceeds the Law Commission.
Yes, long time back. Goswami Commission is.
And the 255th Law Commission report
Yes.
refers to the Goswami Commission.
Yes.
And it has also made its recommendation.
Yes.
In 2015.
Yes.
We are conscious of that.
Yes. So 2015 is the last report of among these commissions, that is of the Law Commission. And that's at page 266 of the compilation. I'm not reading that, but broadly, my lord, what they said was
The need for
an independent selection committee, and they felt in their wisdom at that time that that may be secured by having leader of opposition apart from the prime minister, leader of opposition and chief justice. In a way, my lord, that is somewhat a neutral body. Neutral meaning that there is a counterbalance by way of leader opposition coming. But as I said, my lord, both the prime minister and the leader of opposition are stakeholders before the election commission. And if you apply the principle which was enunciated in the NJSC case, they said that the stakeholders should not have a say, because then there may be give and take and so on. So therefore, stakeholders should not have a say. They, of course, they have the right to send the name back if they feel that there is some problem with some particular appointment. But thereafter, if it is unanimously reiterated, they have no option but to appoint. It's another matter that today even that is not being followed.
there
But
the argument could be raised that in the case of appointment of judges,
yes,
part of the reasoning which way to the court was that judges know who are the most suitable persons. At least that was a theory. They know whether with chief justice, they know the collegium system works on that basis. But here, when you're selecting, mostly it will be IAS officers. Can the judges of the Supreme Court perhaps lay claim to know about the credentials, competence, character of the individual judges? I mean, of the individuals concerned.
in my respectful submission, my lord, yes.
There might be that issue.
Yes, no, I know that there is a slight difference, not identical. But this court, my lord, deals with every kind of case, including such cases like appointment of election commissioners and so on. All these matters come to this court. Ultimately, my lord, what has to be done? Somebody has to apply his mind to see, all right, what are the needs for having an election commissioner? What is the role that the election commission will be playing? And therefore, what kind of qualifications or what kind of things are required or recommended for such people as being election commissioners? And therefore, who should be selected? true that there may be a slight difference between the knowledge that judges have of judges versus the knowledge that judges have of people who are being selected for election commissioners. There may be a difference, slight difference there. But it is outweighed by the overwhelming advantage of their being politically neutral. Judges are at least politically neutral to the question. They are not stakeholders in elections. So therefore, in my respectful submission, my lord, the neutrality of the selection committee will outweigh. Of course, they can receive whatever recommendations, they can receive recommendations from the government, from the leader of opposition, etc. They can consult the government and the leader of opposition. Yes, for sure, they can consult them. They should consult them. Not just the leader of opposition, the other opposition parties or the other political party, they can receive proposals from them. But the ultimate job of selection should be by a neutral body. And I am saying that neutral bodies that who are not stakeholders would be, of course, the judges, the judiciary, the collegium, would also be, in my respectful submission, the Chief Election Commissioner, would also be the Chairman of the National Human Rights Commission, would also be the Controller and Auditor General. So such people would be their constitutional authorities, constitutional or statutory authorities. And
We have two things to say.
yes,
There are no benchmarks for the purpose of making an appointment of a chief election commissioner
I don't think so.
under the constitution. So whosoever is considered the best suitable
Yes,
person out of the under the consideration
yes,
can be appointed.
yes,
Because otherwise you find everywhere there are benchmarks.
yes,
You must have this age, this qualification, this background, whatever it is.
yes,
Here this clean, it's complete clean.
yes,
It is for the discretion to the committee, which the person they think proper, and a suitable person for this post can be appointed.
yes,
There can't be anything more to that.
yes,
Now, as you said, the stakeholders.
yes,
Now, as my brother suggested to you, we are the stakeholders now when we are making appointment of judges and we are recommending name of the lawyers for judges.
no, no.
Now, from other corners, these are the grievances being raised against us.
The judiciary is not a stakeholder. Judiciary is not a
We are
stakeholder.
making appointment
No,
of
no.
the very person which we know.
No, stakeholders can
So
be,
people are making comments.
if there is
We may say
nepotism,
that
if there is nepotism, then
yes,
yes.
that is one thing. We may say that we are independent, we are examining in totality, we know the kind of a credentials, we know his caliber, we know his judicial approach. Correct? But still, we can't rule out the perception of the common man.
No, your lordship is right. So one of the things which your lordship mentioned is extremely important, transparency.
We have to.
Your lordship is right that ultimately it is the character, but we can lay down several safeguards to ensure that wrong people do not have to be appointed.
Suggest this.
Yes, sir.
safeguards according to you.
Safeguards are firstly, selection should be by a neutral body. This is the first safeguard. Most important safeguard. Second safeguard, selection should be with some degree of transparency. That means whatever their selection committee is there, whatever, whoever is the selection committee, the names of the proposed appointees or the shortlisted appointees should be made available to the public before the appointment is made, because I say the same about judiciary also. I have said that, I have maintained this throughout, because what happens sometimes is people don't come to know that so and so is going to be appointed, and they may have some very relevant information about that person, which may disqualify that person from being appointed. So therefore, that degree of transparency is absolutely essential. That means you at least disclose before this appointment is finally made, you at least disclose the names of the proposed appointees. Who are the people that you are proposing to appoint? So transparency is another aspect which is very important. So first neutrality and second transparency. And of course, I say that certainly the selection committee should consult the government and the opposition, etc., whoever they can consult. Of course, the second best alternative is to select what the law commission recommended. That's the second best in mind. But the best option is to have a neutral body to select. Coming back, my lord. So the law commission said this. Then the first commission was the Dinesh Goswami committee. And they had suggested, that was in 1990. They had suggested Chief Justice of India and leader of opposition. And in the absence of leader of opposition, then consultation with the largest opposition group. That's the committee that they had recommended. Then came the National Commission to review the working of the Constitution, which was headed by Justice Venkatachalaya. They suggested Prime Minister, Leader of Opposition in the Lok Sabha, Leader of Opposition in the Raj Sabha, Speaker of the Lok Sabha, and Deputy Chairman of the Raj Sabha. One other thing which I should mention. In order to avoid arbitrary appointments or arbitrary selections, it is better to have a slightly larger body. For example, 3 is better than 1, 5 is even better than 3. So of course, it should not be so unwieldy that it becomes impossible to convene their meetings and get them to function, etc. But
3 being the ideal.
5 in my view.
No, 3 being the ideal number has already been pronounced upon in TN Sessions case. In TN Sessions case, you can see the discussion there. When the government changed it by the ordinance in 1993. Initially, it was only
3
one
numbers of election commissioner.
election commission.
Ah,
If you make it a very unwieldy group, you will have possibilities of independence being compromised because of that. So the lesser number of people available for the powers that be,
so sure about that. I feel, my lord, of course, it should not be unwieldy.
it should not be unwieldy.
Should not be unwieldy. I agree with that. But one person, my lord, if you leave the discretion to one person,
That's what happened with.
there is a
Session.
much larger scope of arbitrariness.
That's exactly what has happened with Session. Some of the remarks made against Session in the Sessions case by the court, which led the government to actually constitute the commissioner, the election commissioner.
No, he was independent, but he was also very dictatorial.
Exactly.
He was.
See, there are so many aspects to be balanced.
Yes, your lordship is right. What I was saying was that in the selection committee, actually this question arose when we were discussing the draft of the Lokpal bill, etc. Who will be selecting the Lokpal? And therefore, I had always felt that the selection committee should be a sort of broad selection committee of maybe 7 people who should select the Lokpal. But, so therefore, the government may have 1 person there, the opposition may have 1 person there, but then 5 independent bodies should also be there, so that the dominant people who select are independent, not really the stakeholders, so to say. So, in my respectful submission, my lord, the ideal number of the selection committee for the election commission should be 5. It's not too unwieldy, and it will ensure that the arbitrariness is reduced substantially. So 5 could be 5 members of the collegium, 5 could be 3 members of the collegium plus, let's say, the outgoing election commission plus the Human Rights Commission.
You have made that point. You have understood your point.
Yes.
So now what more is it that you want to say?
So then, my lord,
You're relying on all the reports.
Now
information.
Now I want to read some very important observations in these judgments.
Yeah. See, you have not yet taken us through the text of Article 324, which we will request you to. do.
Yes, yes,
But only then we will have a,
yes, yes,
what are we doing actually?
yes, my lord.
Because
Yes.
there's no,
Yes,
there
of course.
is no challenge to the constitutional provision of being a basic structure or anything of the kind. We have to take the constitution as it is, obviously.
Yes, yes, yes.
So we take Article 324 as it is
Yes, my lord.
and try to do what we can.
Yes.
Huh? So let us say 324 in its entirety.
The superintendent's direction and control of the preparation of electoral rolls for and the conduct of all elections to parliament and the legislature of every state and of elections to the offices of the president and vice president held under this constitution shall be vested in a commission referred to in this constitution as the election commission. The election commission shall consist of the chief election commissioner and such number of other election commissioners, if any, as the president may from time to time fix, and the appointment of the chief election commissioner and other election commissioners shall, subject to the provisions of any law made in this behalf by Parliament, be made by the president.
So this is a key provision.
Yes, this is the
So
key.
your case is
Yes,
that as things stand, as it stood even at the beginning of the constitution,
yes,
the power to appoint lay with the president, continues to lie with the president. Now, the president obviously means president acting on the advice of the council of ministers.
yes,
So therefore, the council of ministers at present decides to appoint, and this power is subject to any law made by parliament.
yes,
No law has been made. So there is a gray area, there is a gap.
yes.
So there you bring in Vineet,
Vinit Narayan, Prakash Singh,
and then Vishaka also,
yes,
where you can perhaps, the court can fill in the gap
yes,
without doing violence to the terms of the constitution.
yes.
This is what you are, sum and substance of your cases. Whether we can evolve a system of appointment, having regard to the dire need for doing so, for the reasons which you have mentioned, till such time as the law is made, because we cannot possibly be ending up laying down, even in Vishaka, the court say, lay down the guidelines till a law is made, and it took a good 2 decades thereafter, or perhaps even more, for Parliament to respond with actual lawmaking, which
course.
prevails today.
Of course, my lord,
That
if
is
you're-
a short area, that is an area where we can actually step in. This is what you are trying to say.
but the only thing is that,
We cannot say that Parliament is foreclosed from exercising its legislative powers based to entry 72 of list 1.
I agree.
Yes.
Of course, if this court says that we are giving this direction, that the selection shall be by this kind of an independent or a neutral committee. Selection and appointment are slightly different. Of course, appointment has to be made by the president.
That's right.
But selection can be made by different committee. Then that law could also be
That is a
fine.
gray area. That is the area
Yes,
where
that's the area.
we can perhaps step in.
Yes, correct. That,
Till a law is made by Parliament. Because
Alright.
we cannot possibly stop the Parliament from making a law. As to whether that law can be challenged separately, that's a different matter.
yes, same thing happened with NJAC.
Exactly.
NJAC.
We can't stop them from making a law, but then if they make a law,
We made a constitutional amendment
that's right.
and that was also struck
Absolutely,
down.
absolutely.
Same thing happened in that
Now you can
UCL and ADR. Same thing.
perhaps read Article 324(5).
Yes,
Yes, we may not read the whole of it.
yes,
324(5) also.
yes, that's important.
Yeah.
Subject to the provisions of any law made by Parliament, the conditions of service and tenure of the election commissioners and the regional commissioners shall be such as the president may by rule determine.
So pause for a moment. That's a law was put in place in the year 1991, as you know. They made a law traceable to conditions of service and tenure, but relating to appointment per se,
They didn't make.
relating to Article 324(2). No law has been made by Parliament.
Yeah. That's right.
This is what is perhaps the position.
Yes, correct.
Then the important thing is the
Proviso,
provisos, the two provisos.
provided that the chief election commissioner shall not be removed from his office except in such manner and on like grounds as a judge of the Supreme Court, and the conditions of service of the chief election commissioner shall not be varied to his disadvantage after his appointment. So this provides for that functional independence,
That's right.
so that the government doesn't have control over his conditions of service or his removal, etc.
That's right. There's an appointment and removal. The appointment is governed by 324(2). Removal is already provided for in 324. And there is no scope for the court to say something contrary to what is expressly provided in the constitution.
Right. And
So
so
we are
far,
concerned essentially with how you go about appointing the chief election commissioner and also the election commission.
correct.
We take it that's your
That's the
only short point is about the appointment.
correct.
We can't be ruling on.
No, in my petition, but in one other petition, I believe the issue is also about the rules, etc. In my petition, both petitions, the only short issue is regarding appointment.
So you've made these proposals, and then what is the state of the law in other countries? You have mentioned about South Africa, Ghana, in the US. You have given practices prevalent in these countries as well.
I have not really.
We have seen some of the other cases, like in the US, I think it has to be approved, president appoints, but it has to be cleared by the Senate.
Yes.
Correct.
Yes.
Now you take a case where.
There are divergent models.
Huh?
There are divergent models across the.
There are different models.
That's it.
Not exactly.
So in any case, my lord, here I am going purely by the basic principle which your lordship has laid down. That is, in the NJSC case where your lordship said that look, judiciary has to be independent of the government because government is a major stakeholder.
That's right, absolutely.
Same principle I am applying here. Exactly the same principle. Election Commission has to be independent because government is a major stakeholder before the Election Commission. Just as rule of law and justice is a basic feature of the Constitution,
You have made that point.
democracy and free
No.
and fair elections.
Okay, then you could perhaps move on
Then
to the
the-
decisions you want to lay out.
Yes, my lord.
And then we can.
First, this fellow, the SCORA, which I have quoted the relevant paragraphs in this, at page 6 of the note, Lord, at the bottom, no one can deny, this is the quotation.
Mr. Bhushan, give the citation.
Yes, the citation, that is 1993, 4 SCC, page 441. And I am reading para 207, which I have quoted.
93.
93, 4 SCC, 441. In my note, my lord, everything is.
The compilation containing all the judgments.
Yes, no, this judgment is not in the compilation.
We have a compilation meeting.
Acha, of the judgment.
Particular number of judgments which have been given, we don't know whether this is a part of it.
I'm not sure whether, this must be there.
Okay, just give us the citation.
1993,
Yeah.
4 SCC, 441. And I'm first reading, my lord, para 207.
But this is there in his note, which he has reproduced that.
That's good. So paragraph,
Paragraph 207.
you may indicate a paragraph.
Yes, yes.
Unless you want to read a
There.
particular question, just give us a paragraph, we'll go through it.
Acha, all right. 20,
We'll spend the.
all right. 207.
Yeah.
And here they say why the appointment is essential, why the appointment cannot be controlled by the government, or that the government can't be the prime mover so far as appointment of judges is concerned. Why independent appointment is necessary for securing an independent judiciary. They
Yes.
say that very clearly. So 209, they say the aforementioned discussion, I'll just read this one sentence, leads to an inescapable conclusion that all the factors mentioned above coalesce to support the view that the executive will not be justified in enjoying supremacy over the opinion of the CJI in the matter of selection of judges to the superior judiciary. So, and then, my lord, they, para 321,
Para 321.
334,
Yeah.
and 334, one quotation which I'll just read, which is important. It is not the security of tenure provided to an individual judge which alone is the source of independence of judiciary. But there has to be an independent judiciary as an institution. The judiciary in India has to act as an impartial umpire to resolve disputes between governments and private individuals as well as between governments inter se. It also has to protect fundamental rights of individuals guaranteed by Part 3 of the Constitution. The courts in this country have already expanded the scope of judicial review by bringing in its ambit social, economic and political justice. Keeping in view the expanding horizon of judicial review, it is the paramount need of the time that not only the independence of the individual judge is to be secured, but the independence of judiciary as an institution also has to be achieved. The question that comes up, 335, then 335, the question which comes up for consideration is, can there be an independent judiciary when the power of appointment of judges vests in the executive? Same thing here with the Election Commission. To say yes would be illogical. The independence of the judiciary is inextricably linked and connected with the constitutional process of appointment of judges of the higher judiciary. Independence of judiciary is the basic feature of our constitution, and if it means what we have discussed above, then the framers of the constitution could never have intended to give this power to the executive. In fact, my lord, in the Constituent Assembly discussions also, the expectation of Dr. Ambedkar was that some law will be made to provide for some independent.
We are bearing that now.
Yeah.
Next judgment you are
In the form, the Union Executive has vital interests in various important matters which come up for
You
adjudication.
know that we have
Yes.
seen that. Yes. So that-
Then the next judgment is
Yeah.
Roger Matthew versus South Indian Bank,
Yeah,
2026 SCC, page 1,
yeah. Paragraph?
about the tribunals. Paragraph 153
Yeah.
says, Roger Matthew, 2020, volume 6 SCC, page 1.
Then
We are-
you take it that you will read each paragraph, each sentence of it, we will go through it.
All
remember?
right, all right, all right.
So that, you know.
So the basic point, the same thing they say about the tribunals,
That's right.
which they say about the judiciary. Then, my lord, in the second SCORA case, that is the NJC case, 2016 5 SCC, page 1. Here, I have mentioned several paragraphs. I have reproduced several paragraphs which talk about the dangers of having this reciprocity. That is all right. You have the government also, you have the judiciary also in the selection of judges. Because there the law minister was there in the NJC Act as one of the people in the selection committee. And the secretariat was vested with the law ministry and so on. So they said this will lead to the danger of reciprocity, etc., which is also a big problem for the independence of the judiciary. That, all right, you appoint one of yours, we'll appoint one of ours, and so on. So, so that is why they struck down, look, government should have no role in this. And on that basis, they struck that down. So, para 310, 11, 12, 13, whole thing deals with the danger of
We'll
this.
deal with it. We'll deal. Next.
13, 14,
Yes.
15 to 16, we've given a long 17
Yes.
to 17, 19 till para 319. Then, my lord, so they deal with it in great detail, this problem with reciprocity and government having, that it will lead to this problem. And then, my lord, the next.
Bhushan, just we would like to ask, just as an aside,
Yes,
we'd like to ask you one question.
yes,
Is there any system
yes.
devised by human beings which can be perfect?
No, no,
Cannot.
certainly not. No,
It cannot be.
Yes.
Because
Can't be.
of our follies and our frailties.
yes, of course,
And our character or the lack of it
no doubt.
more. That whatever system you may have,
Yes,
for example, even the collegiate system by which my learned brother pointed out,
has problems.
it has problem.
Yes,
So we have to, the most important thing is the pursuit of truth.
And to make the best
should be more
possible.
important than pursuing what is the truth.
and to
So if
make
you
the
pursue
best.
truth to its end, we'll have problems. So
We'll not-
let us not take it beyond a certain limit. Because there is, we are imperfect, we continue to be imperfect, but we try to make the best of it. And that's what I think you are also trying.
Oh, Russell said something very interesting and important. He said,
In fact, if you have read Palkiwala's We the People, way back in 1989 when it was published, the whole book is based on the premise how we as a nation have lost character. And all this debate, all we are spending time over in pursuit of that little quality in at least some of our citizens.
so Russell
That is
said,
the tragic, state of affairs that we are reduced to.
so Russell said
All these discussions.
something,
People of character.
something important about character. He said, institutions mold character and character transforms institutions. So, in a science fiction novel long developed the technology of non-invasively seeing every neuron, every chemical reaction in anybody's brain. So today, I point my phone towards you and I can see exactly what is happening in your mind.
It's going to happen. What you
It will happen. It will happen.
It's likely
someday.
to happen.
Now the question is, what would happen? So some of our transparency activists who disagree with me,
Bhushan, one more thing, because to have a clarification. No, whether the petitioner seeks for a direction, we are not saying to the parliament, to come up with a law in terms of a 324(2), or this court to constitute a body in the interregnum for the purpose of the 324.
second, what your lordship just mentioned.
Make it clear, make it clear.
Yes. I am not asking for a direction to parliament to make a law. Not
That is the prayer, that is why, that is why, time and again we put that.
That was the prayer in the unamended petition, which we amended subsequently. And that amended petition.
Second also, the amended petition also, you are seeking a writ.
Yes.
Seeking a writ means, you cannot say that, no, it is not to anybody.
No, it is a writ
To whom?
in general, just
To
like,
whom?
just like, my lord, the writ.
That is why we put this question, whether the first part or the second part.
So
Because we will have to be very clear on that.
it's
See, of course, 322(4), 24(2), it casts an obligation. It is there. But at the same time, are you seeking a direction or a writ to come up with a law, or in the interregnum, this court to constitute a body?
I am not seeking a direction to come up with a law.
Make it clear.
I am seeking a direction from this court
That
to
is
the
right. Only
government
to make.
to constitute a selection committee in line with the directions of this court in order to secure the independence of the election commission, or in order to secure that the election commission is appointed independently and not appointed by the government alone. That's all.
Only to have a
Yes.
clarification on it.
So I was saying, my lord, that
Back in 1 minute.
yes, of course. I was at page 15 of my note. The second, or the next case that I have referred to is Prakash Singh.
Yeah,
That's regarding police reform.
that's right.
So,
That citation.
it's 2006,
Yeah.
8 SCC, page 1. Before that, Lord, I was, in the context of character, I was saying, suppose we develop that technology, which I was mentioning, what would it do to character? It's a very, very important question. If I could see, or if everybody could see what is going on in everybody else's mind, one of the consequences of that, of course, my privacy friends are aghast. Should there ever be some technology, there won't even be privacy of mind, what to say of any other privacy. But one consequence, one good consequence would be that at least cheating would disappear in such a society. So character of people would get molded so that they don't even think of cheating because they'll be caught out immediately when they think of cheating. So therefore, character is also a product of systems, etc. So if you make a transparent system, for example, then the chance of the person who is manning that system to act arbitrarily gets reduced to that extent. And that's why all these systems play an important role in determining how people will behave.
Correct. Mr. Bhushan, your Snoopy invasion, you are expecting that there will be only pure thoughts in the minds of the people.
No, I'm not expecting that.
No, I mean.
Not at all. In fact, my lord, this is one of the concerns which was raised.
No, I understand that, of course. Take it in that spirit only.
People might start thinking in code language.
Very interesting thing recently happened in US in some antitrust investigations. It was found that all these technology providers around the world, Google and so on and so forth, they were found to caught discussing one very important aspect, that how to economically grow. And the one idea came to them is consume every human minute. So every human existing on this earth, bring them on a technology platform and monetize that time. So the technology maker who's going to bring this technology with the idea of bringing character in, so he's going to have a further idea, which is the basis of cheating and so on and so forth. And this has been actually caught, which was considered in the US Senate, how the technology providers should be regulated. So they go down that route, saying that every human minute should be consumed.
It's just to add, there's a very interesting book written by a New York journalist, World Without Mind. So it all looks up Facebook, all these technology giants, and how they grew. Therefore, on the one hand, you're talking about freedom of the mind. The other hand, we're talking about freedom of technology. So it's a very interesting book. Never necessarily.
So, Lord, I was coming back to my report. The next case is Prakash Singh, 2006 8 SCC paragraphs 26 and 26 to 31. I'll just read out a few things. 26 in para 26, they say, having regard to the gravity of the problem, the urgent need for preservation and strengthening of the rule of law, the pendency of even this petition for the last over 10 years, the fact that various commissions and committees have made recommendations on similar lines for introducing reforms in the police setup in the country, and the total uncertainty as to when police reforms would be introduced, we think that there cannot be any further wait. And the stage has come for issuing the appropriate directions for immediate compliance so as to be operative till such time a new model police act is prepared by the central government and or the state governments pass the requisite legislation. Pausing here for a moment. Of course, the directions which included appointment of police chiefs, etc., were till such time that a new act is come. But thereafter, some states brought new acts which were totally out of line with these directions about the need for having some independence of the police and insulating the police from overwhelming government interference, etc. This was the object of these directions. And they were premised on the basis that for preservation of the rule of law, it is essential that the police does not remain completely controlled by the government. So they struck down and in some cases stayed the operation of these acts which were brought, which were out of line with the basic judgment. Then, my lord, one other important paragraph, they say, para 29, the preparation of a model police act by the central government and the enactment of new police acts by the state governments providing therein for the composition of the State Security Commission are things we can only hope for the present. Similarly, we can only express our hope that all the state governments would rise to the occasion and enact a new police act wholly insulating the police from any pressure whatsoever, thereby placing in position an important measure for securing the rights of citizens under the Constitution and the rule of law, treating everyone equal and being partisan to none. Of course, police is much less important than the Election Commission, which will also help in securing an efficient and better criminal justice delivery system. It is not possible or proper to leave this matter only with an expression of this hope and await developments further. It is essential to lay down guidelines to be operative till the new legislation is enacted by the state governments. Article 32, para 30, Article 32, read with 142 of the Constitution, empowers this court to issue such directions as may be necessary for doing complete justice in any cause or matter. All authorities are mandated by Article 144 to act in aid of the powers passed of the orders passed by this court. The decision in Vineet Narayan notes various decisions of this court where guidelines and directions to be observed were issued in the absence of legislation and implemented till state legislatures pass appropriate legislations. So therefore, my lord, it's quite clear and it's been said in several cases that you can do this.
Vineet Narayan onward.
Yes, Vineet Narayan, Vishaka.
Absolutely, absolutely. You
All
don't
these.
have to take it.
Yes, yes. Then, my lord, next case that I have referred to is Vineet Narayan.
Thank you.
That is 1998, 1 SCC, page 226. Again says the same thing, that there are
Para
ample power
149, yes.
and that
That's right.
there is a gap, we can issue an order to
That's
fill in
right.
that gap, etc., etc. And they note all those various earlier judgments also to that effect. And finally, the paragraphs are, my lord, which we have mentioned, 49, 51, 52,
Yeah.
53. And para 52, they say, it is pointed out in Vishaka that it is the duty of the executive to fill the vacuum by executive orders because its field is coterminous with that of legislature. And where there is inaction, even by the executive, for whatever reason, the judiciary must step in exercise of its constitutional obligations under the aforesaid provisions to provide a solution till such time as the legislature act to perform its role by enacting proper legislation in the field. And the last case that we have mentioned is the special reference number 1, also Spora, my lord, where they said that it will not be the Chief Justice alone but the collegium. That is 1998, 7 SCC, page 739. And I have mentioned only para 44. So therefore, my lord, my respectful submission is that election commission has to be made independent. That is an absolutely core requirement of the basic feature of the Constitution for the functioning of democracy. And that in order to make it independent, this election cannot be left in the hands of the government alone.
Yeah.
And in my respectful submission, my lord, in line with the judgment in the NJAC case, it is much better to to leave out the stakeholders or the important stakeholders from the selection committee
Yeah,
and place it in the hands of
Yeah.
a totally independent body
yeah.
like the collegium, etc. But the second best alternative is what the law commission suggested. So, my lord, this is my respectful submission that the one other thing in the second case, which I am appearing in, that writ petition 569 of 2021, there is also an interim application that because there is one post still vacant.
What are the prayers in 569? Is it the same?
569, the prayer is, first is, this is important, my lord, this prayer is important in this 569 because this prayer, first prayer was not written in this manner in the other petition that Anup Paranwal. First prayer is page 25. Issue an appropriate writ, order or direction declaring the practice of appointment of the Chief Election Commissioner and election commissioners solely by the executive as being violative of Article 324 and 14 of the Constitution. Actually, it should be declared violative of the basic structure of the Constitution, that is democracy. This practice is violative of the basic structure of the Constitution, and then direct the respondents to implement an independent system for appointment of members of the Election Commission on the lines recommended. I have made a slight variation in this in my submissions, my lord. I have said not merely on the lines recommended by that, but going further, taking a cue from NJC judgment that a neutral selecting body, because all those recommendations mentioned the Prime Minister, Leader of Opposition, etc. Prime Minister, Leader of Opposition is almost common in all those various commissions' recommendations. Most of them also have the Chief Justice in this. There is, I think, an interim application which we had filed in this matter. There is an application for interim directions at page 106 in this ADR, where we have said that till such time that the court gives its final judgment, but at least in the interim, prayer is at page 120,
Yes.
the interim prayer. That direct the respondents to appoint the election commissioner to the vacant post through the Collegium Selection Committee as recommended by the law commissioner or the other commissioner.
Yes.
Because today also there is one post of election commission vacant. So I am saying that even if the judgment takes some time, if the judgment comes quickly, then there is no problem, no need to go into it. But
But
even,
taken us through that 91 Act.
yes,
In the 91 Act, prescribes the terms and conditions under reasonable to 324(5).
Mr. Shankar.
Oh, all right. So that there will be apportionment. Yes. Thank you.
I am obliged.
So now, Saudi, you're appearing in the petition.
The writ petition number is 998 of 22.
998 of
22.
Yeah.
what is the prayer you saw from saying?
No, different aspect I want to stress here.
Implement and a transparent system of appointment.
Agreeing by and large with what endorse what my friend argued, but I'll only supplement it very
You adopt it and then supplement it.
supplement.
Adopts,
So the question is, sir,
Shall
this
we?
court is, what is this court?
supplements. Yeah.
Who is the petitioner? What, sir?
Sir, the question is here that this court will protect not only
No, we are asking who is the petitioner and what, sir? And
Dr. Jaya Thakur.
Okay.
Your prayer says it all. Basically, your
They are basically there, but from a different perspective altogether. I have a different view on it.
Yeah.
Which will help this court to decide as to what order should be passed.
Yeah.
I don't have to stress that this court is not only a protector of the provisions of the Constitution, but also a protector of the constitutional morality and constitutional ethos. Whenever we interpret the Constitution, we have to keep in view, point of view, this idea of constitutional morality and constitutional ethos. Whereas when we interpret a statute, this is not so. This principle is not applied when we interpret a statute. So basically, it has to be a purposive interpretation of the Constitution. Provisions. Where do we gather what was the intention of the Constitution makers? And that intention, has it reflected in some part? Yes. And what was the expectation of the Constitution provision? It was expected that as they have protected under 324(5) proviso for keeping the independence of the Election Commission, that the removal of the Chief Election Commissioner is not parity with the Judge of the Supreme Court. Why? Because that it is no less important, its independence is no less important, the election commissions, than that of a Judge of the Supreme Court. The independence is as important of the election commission and Chief Election Commissioner and the commissioners as the judges of the Supreme Court. That's the basic requirement. Now, please come to this, the appointment is 324. I'll say why it is almost made redundant by the executive. The entire provision has become literally Osho's, I would say so. Because what was expected at that time, that the chief I'm reading 324(2). The election commission shall consist of the chief election commissioner and the number of so and so forth. If any, as the president from time to time fix an appointment of the chief election commissioner and the other election commissioners shall be subject to, shall. The word used is shall, not may. Shall be subject to the provisions of any law made in this behalf by the parliament. Now, if no law is made, then what happens? The appointment is subject to that, but if there is no law made, it is subject to nothing. Isn't it that the expectation of the constitution maker, the ethos of this particular provision is completely lost? It has made this provision redundant. So this court can step in to ensure that this situation cannot continue to exist. That's the point. And this court has sufficient powers to ensure. Now, what was the Dr. Rajendra Prasad, sir, it's very important on the Constituent Assembly debates, apart from what Dr. Ambedkar has said. Please pass. Yes. Very interesting is some of the questions that were posed by the others. And that, I don't know why, whether Dr. Saxena, who raised this point, was clairvoyant, because he definitely, whatever he had imagined, probably is coming true. I'm referring to page 907.
907.
907.
Yeah.
This is the Honorable President, Dr. Rajendra Prasad. Sir, I must congratulate Dr. Ambedkar on moving this amendment. As you have said, this amendment really carries out the recommendations of the Fundamental Rights Committee, and in fact, the matter was so important that it was thought at one time that it should be included in the fundamental rights. See the importance of this. The real purpose is that the fundamental right of an adult franchisee should not only be guaranteed in practice. He has explained to us that he has tried to make the election commission, shall not only be, but also guaranteed in practice. He has explained to us that he has tried to make election commission wholly independent of the executive. And he therefore hopes that by this method, the fundamental right of the executive, that is, hope that by this fundamental right to franchise of all individuals will not only be guaranteed, but that it should also be exercised in proper manner so that the elected people will represent the true will of the people of the country. After careful study of this amendment, I have suggested my above amendments to carry out the real purpose of Dr. Ambedkar's amendment in full. What is desired by my amendment is that the election commission shall be completely independent of the executive. Of course, it shall be completely independent of the provincial executive, but if the president is to appoint this commission, naturally it means that the Prime Minister appoints this commission. He will appoint the other election commissioners on his recommendations, the cabinet form of government. Now, this does not ensure their independence. This does not ensure their independence. Of course, once he is appointed, he shall not be removable except by 2/3 majority of both houses. That is certainly something which can instill independence in him. But it is quite possible that some party in power who wants to win the next election may appoint a staunch party man as the chief election commissioner. He is removable only by 2/3 majority of both houses on grave charges, which means that he is almost irremovable. So what I want is that even the person who is appointed originally should be such that he should be enjoying the confidence of all parties. The enjoying of confidence is very important, sir. Inspire confidence. You must inspire confidence. Should be confirmed not only by majority, but by 2/3 majority of both houses. If it is only a bare majority, then the party in power could vote confidence in him. But when I want 2/3 majority, then it means that the other parties must also concur in the appointment so that in order that the real independence of commission may be guaranteed. So the concur word, this court remembers in that Palladium matter this court decided, concurrence was said to be important, not merely consultation or history, but concurrence is there. That is the only way of effective consultation. Where is it? In fact, there is no consultation here at all. The president is bound to, by the cabinet recommending the prime minister, that says being the prime minister, he is bound to appoint without fail. Then alone he can get 2/3 majority in support of the appointment. I therefore think the real purpose of the recommendation of the Fundamental Rights Committee, etc. Now, please, that's a very interesting question asked, sir. Professor Shubhan Lal Saxena, I admire this gentleman's clairvoyance at that stage. At this time, nothing will help in this matter. Whosoever will put forward will be elected. But we are making a constitution forever, and not only for today. Today, of course, whoever is appointed by the president on the recommendation of the cabinet will be approved. We are lucky in having our prime minister a man of independence and impartiality, and he will see that a proper person is appointed. But we cannot be sure that the prime minister will always be such a personality. I want that in future no prime minister may abuse his right, or for this I want to provide that there should be 2/3 majority which should approve the nomination of the president. Of course, there is a danger where one party is a huge majority. As I say, now it's quite possible that if our prime minister wants, he can have a man of his own party. But I am sure he will not do it. Still, he does not. If he does not appoint a party man, an appointment comes from confirmation, etc. So these are the apprehensions which I think are coming true, but otherwise, then Patiskar sir, who later on became the governor of the CPN Barar and the first state of Madhya Pradesh, old state of Madhya Pradesh, it was formed in 1948. He comes to page 910.
Yeah.
Mr. President, sir, I've carefully gone through the new amendment, number 99, moved by my respected friend, Dr. Ambedkar. And I've also very carefully listened to the arguments that he advanced. While I agree with him entirely that the election in any democratic form of government must be free from any sort of executive interference, I still do not understand and realize the necessity of making it wholly centralized. They were against the wholly centralization of this power, giving in one authority the power to do so. That is the only point I'm going to discuss, the difference between original Article 289 and restored in draft constitution and the new article which was suggested by so and so forth. Then this was the only, Mr. Patsky agreed, but he said, I don't agree that everything should be so centralized. Now, in that, in my petition, the second Administrative Reforms Commission, at page 35.
Mr. Chaudhary, what are you actually emphasizing? The inadequacy of the system, which was highlighted at the time of.
No, what I am saying is,
debating.
once procedure for renewal is provided, that is what the Constitution envisages.
Yes.
For the protection of the Election Commission. Now, that should have some nexus with the appointment. That should, and it is expected that that was the nexus which was meant for, to be brought around by a law. And no law is being brought out at all for the last 70 years. So this court can fill in the lacuna.
Yes, that is the
Yes.
Bishakha principle.
So, sir, it's difficult to say what I would expect of this court. There are so many things I would expect, but then this court has to decide whether it can go to fulfill my expectations. I don't want that.
No. But in your client, what does she really want? Some kind of
Some kind of a direction as this court, even the appointment of the judges, this court did come out with collegium system. That was not there in the Constitution. But it did come out, it was upheld up to the 9 judges of this court.
essentially you want a selecting body by this court, I think.
So I want to lay down, this court should lay down some guidelines, lay down some procedure by which the selection should be made. I don't expect this court will interfere and say you appoint this or appoint in this particular manner. But somehow,
Those who will select, you want some kind of guideline for them.
yes. And keeping this in mind, that the independence of this election commission is as important as the independence of this court. And had that not been there at all, we would not have had this collegium. So I can't say that there is absolute 100% perfect. No system is, there is no frictionless machine. We can't have, there are bound to be aberrations. We have to try to ensure that as less aberrations are there as possible. As less.
Yeah.
Completely we can't.
So this commission, that's a second reforms commission,
Yes.
which part you want to emphasize?
So this,
Page of your,
so this was the second Administrative Reforms Commission, page 35. I am referring to page 36.
what is the date of this commission report? What is the, when
This
is
is written January 2007, sir.
January 2007.
Yes.
And what does it say?
Sorry. 2007 का बता रहा है, 5 देगा. I think they give the wrong thing. January 2007.
Yeah.
And it's titled as Ethics in Governance. Page 35.
Page 37, yes.
Yes, at 2.15.1. The present procedure, sorry, sir, have you got that? The present procedure for appointment of Chief Election Commissioner so and so is laid down in Article 24. The next, 2.1.52. During debates in the Constituent Assembly on the procedure for appointment, there were suggestions that the person appointed as the Chief Election Commissioner should enjoy the confidence of all the parties, and therefore his appointment should be confirmed by 2/3 majority of both the houses. Thus, even at that stage, there was a view that the procedure for appointment should be broad-based, one above all partisan considerations. In recent times, for statutory bodies such as National Human Rights Commission and the CVC, appointment of chairperson and members are made on the recommendations of the broad-based committee. Thus, for the appointment of Chief Vigilance Commissioner, the committee consists of the Prime Minister, the Home Minister, and the Leader of the Opposition in the Lok Sabha. Whereas for the NHRC, the committee is chaired by the Prime Minister and has its members, the Speaker of the Lok Sabha, the Home Minister, the Leader of the Opposition in Lok Sabha, the Leader of the Opposition in Rajya Sabha, and Deputy Chairman of Rajya Sabha. Given the far-reaching importance and critical role of the Election Commission in the working of a democracy, it would certainly be appropriate if a similar collegium is constituted for the selection of Chief Election Commissioner and the Election Commissioner. Now, there's the recommendation. The collegium headed by the Prime Minister, with the Speaker of the Lok Sabha and the Leader of the Opposition in the Lok Sabha, the Law Minister, and the Deputy Chairman of the Rajya Sabha, as members should make recommendations for the consideration of the President for the appointment of Chief Election Commissioner and the Election Commissioners. That's how it's just recommendation mode. And of course, if we say Leader of the Opposition, then there comes the point, they said there's no Leader of the Opposition, so we can't comply. So the rider.
Just look at the suggestion which is made. Collegium headed by the Prime Minister.
Yes.
The Speaker, then of course just eclipse Leader of the Opposition.
I'm only insisting,
And the Deputy Chairman
yes.
should make it. Now the Prime Minister, the Speaker, and the Deputy Chairman of the Lok Sabha.
It comes the same way. Exactly. No, I'm stressing only on the collegium part.
What purpose will it serve?
No, I'm not saying that this is followed, but
You're
Yes,
saying that it's important.
collegium.
The immediate collegium.
yes, a collegium. So on
You must
aspect
get-
only is of that collegium. That's all. Then
Anything more? Anything more you want to say? Anything more, Mr.
then on 31st of August, there was another resolution passed at the Commission, Administrative Reforms Commission, dated 31st of August 2005.
Anything more?
It's headed by Mr. Veerappa Moily, he was then the
That's it.
Law Minister. As we turn over the page, at 2.1.5.1.
Yeah.
The present procedure of appointment of the CEC and the other election commissioners is laid down in 324 of the Constitution and stipulates that they are to be appointed by the President on the advice of the Prime Minister. During debates in the Constituent Assembly, the procedure for appointment, there were suggestions, and they are there, so I will not repeat that. It's coming to the same thing which I have already.
Anything more?
Therefore, sir, I would request that this court would have to have a real proactiveness be shown. For what? For only protecting the Constitution and its ethos and morality. That this court can and has to step in to protect, come what may.
Yes.
Come what may.
Thank you. Good concept. Who else is there?
Shall I make one submission?
Wait, please, Manoj.
Gopal,
I'm appearing in writ petition 1043 of 2017.
take that as the petition.
The Lordship may just keep two things, Manoj. One is that convenience compilation. Second is a counter affidavit which has been filed in that matter where I am appearing, which has been filed by the Election Commission.
Gopal, I have one request to you.
Yes, Manoj. Don't repeat.
No, sorry, no.
Yes,
You know it, the lawyers always restrain themselves in repeating. Point is slightly different.
yes.
Can,
Whatever the practice being followed in making appointment to the Chief Election Commission or the election commissioners under 324.
Yes.
He said there is no rules have been framed, the procedure has been laid down. We'll call upon them also for this purpose.
Yes.
But for the last more than 70 years, this practice being followed.
Yes.
Number of recommendations and all commissions report have been placed for our revision.
Yes.
But now our question to you is, what is the necessity has arose to individuals collectively or otherwise in approaching to this court or stepping down and lay down a principle as to what the government should follow in making an appointment?
I'll explain.
What we suggest is, but what is going to my mind.
Yes, yes.
If we take a cognizance on what you say today, meaning thereby in the last 70 years more, the appointments which are made on this particular post, either the requirement of constitutional mandate has not been followed, or there's something wrong in the procedure, which we want to now correct. Because somebody has approached to this court and calling upon to intervene, said the government is not coming out with a procedure as 324(2) contemplates.
Fair enough.
That we want.
I'll respond. And I'll give your lordships, I think I should give your lordships an overview of how I plan to address particularly that question and the other. Well, there's been, specifically with reference to insulating institutions, there's been a series of litigations, particularly in this court, over the last couple of decades. We have seen a lot of importance being given to three particular sets of institutions. Those three particular sets of institutions are the institutions which are the underpinnings of our democracy. This court has referred to them as being instrumental in sustaining the basic features of the Constitution. Absent those three, this Constitution and this democracy will collapse. The first of that is the judiciary, and your lordships have seen the efforts over the last 30 years, both as far as this court itself is concerned in institution building, in trying to create a system where there will be some independence, keeping independence of the judiciary at the core. There are only about 7 or 8 judgments of this court which have ever struck down a constitutional amendment. And they are only on 3 finite principles. The first is that there has been an exclusion of judicial review. So your lordships have struck down constitutional amendments on that ground. That's been the large chunk. The second has been on this independence of the judiciary. The NJSC judgment struck it down. And what was that independence of the judiciary that was being protected? The critics will say it was a wafer thin. It was 1 vote essentially on that committee. But it was enough for that wafer thin difference to create a situation which would imbalance the constitutional structure. That's the second. And the third, Manoj, has been about 368(2) proviso not being complied with, a couple of judgments, Yohoto and then this cooperative society. So, this is the importance that your lordships have given, particularly with reference to judiciary. The other principle that your lordships have sustained throughout, and this is why the other institution comes in, is of free and fair elections. In Indira Gandhi in 75, your lordships laid that down. And efforts since then have been on to try and strengthen the very body which will ensure that we have free and fair elections, which is the Election Commission. Those efforts have also been a tug of war. There have been efforts, my lords, to ensure that whatever yeoman service is provided by this court towards insulating the Election Commission, in ensuring that we have a clean and transparent electoral system, has been negated when governments have stepped in. Your Lordship saw that, Mr. Bhushan alluded to it with reference to that ADR and PUCL cases. That was in fact a High Court judgment, which was sustained in Association of Democratic Reform, saying that candidates must give affidavits which mentioned their criminal antecedents and mentioned their assets. When they implemented in law, they carefully forgot one part of the criminal antecedents and brought in only with reference to assets. So we had to have round 2. After which we've had round 3 in Public Interest Foundation. We've had round 4 as recently as last year. When my Lord Justice Nariman's bench went to the extent of saying, look, we're making it very clear. All you political parties on your websites, on your Twitter handles, on Facebook, you are going to put out the details of the individuals who have criminal antecedents that you are hosting as your representatives. You're going to give reasons why you have chosen that person if he has criminal antecedents as your candidate. And if you fail to upload this, and if you fail to give it publicity, the Election Commission is entitled to file a report in this court, in the Supreme Court of India, and it will be treated as contempt of court. That's the level to which this court has given attention to the importance of protecting that democratic system of ours. What Churchill referred to as a little man with a pencil walking into the booth. The reason
For your prayers.
Yes.
That's where
So I'm
retained by your.
I'll explain what my prayers are. I'm supplementing Mr. Bhushan, Mr. Chowdhury on the first point. I have something else to say with reference to the appointment process.
We'll do that.
Yes, and now my 3 prayers.
Yeah.
The 3 prayers I'm pressing.
28.
Page 28. The 3 prayers. And I'll tell your lordships why I am pressing those. The first is with reference to the protection that has to be given to both the election. I don't think so, and I'll explain why. I'll explain, I'll make it good. I have gone through this provision many, many times, as one must. Every time we have to deal with a constitutional issue, reading it once is not enough. I've read it 20 times. I think there is a way for me to press this argument, which is the protection which is given to the Chief Election Commissioner is a protection that actually extends to both election commissioners. That is the first argument. The second is with reference to it having an independent secretariat. And the third is with reference to the expenditures of the Election Commission having to be a call on the consolidated fund, which is not a voted expenditure. The expenditure with reference to the Supreme Court judges, with reference to CNAG, with reference to UPSC, with our other constitutional authorities, are all unvoted administrative expense, which is important, which allows that even when a budget is going to be voted on, this will not be voted on. This is anyway an administrative expense to run the country, which has to go on its own. You can't subject the Election Commission's expenses, the salaries, emoluments of the Chief Election Commissioner and the Election Commissioners to a vote by Parliament. That can't be done. It has to be unvoted administrative expenditure, and this is not just me saying it. That counter affidavit I've shown you, Lordship. Chief Election Commissioner after Chief Election Commissioner with a begging bowl says, please ensure that these are changes that you will bring, both on the Secretariat as well as on the expenses to the consolidated fund.
And what is the third prayer?
That last one about conferring rule making, I am not pressing because I don't think that is necessary at all. That power exists. It's only a recognition, and that recognition is
You're pressing only prayers A and B.
A and B.
A and B.
A and B. And D, I think, will cover even the appointment prayer. Anyway, made in the other 2 petitions. So I don't have to. So now, if I can.
You pick.
I'm sorry. Your Lordship want me to start with that?
Yeah.
I'll start with that.
That's your prayer, because otherwise all the others are covered by various. You can.
No, I will repeat nothing. I just wanted, just before I address your Lordships on, I'll start with that prayer your Lordship want me to. But just before that, I just wanted to complete my response to Lord Justice Russell. So one was the Supreme Court and its judges, and the High Court and its judges, the independence of the judiciary. That's a very, very seriously important pillar. And thankfully today we have some level of insulation and protection. Some level, I still say. We have, of course, they will, at every point, we will find novel ways in which to frustrate the best of efforts. So when you don't need an IB report for a member of parliament, for an MLA, for the president, for the prime minister, for the CVC, for nothing. For judges, we suddenly need an IB report. So it's a novel way. They will find novel ways to keep coming and frustrating the best of efforts to create insulated positions for our most important institutions. So the judiciary is one. The second is the Election Commission. Because they uphold a basic feature which your lordships have recognized as a basic feature. And that's why, since your lordships wanted the citations, I'll give your lordship those citations. The basic feature citations, in addition to Indira Gandhi, which is 1975 supplementary SEC 1, Manoj Narula and Krishnamurthy, I will refer to, which is Manoj Narula is 2014, 9 SEC, page 1, and Krishnamurthy is 2015, 3 SEC, 467. Just on very, and I will take your lordship to paras, etc. later. I just want to briefly tell your lordship. Manoj Narula says that the core of democracy and of constitutional governance is this, of ensuring that you have an independent electoral process which is completely protected. Krishnamurthy says that there is a vacuum in 324 and says that this free and fair elections, it reiterates once again about it being a basic feature of the Constitution. Now, these two large institutions, along with the third, which is the media, and that's why Article 19, 1A, all the various protections your lordships have recognized coming out of 19.1A, the fact that we are always chary about making laws which restrict their speech, etc. These three are most important for the functioning of this democracy. Most important. Media itself is protected because to the large extent it is private, it's independent, it's not dependent on the government. But the other two, one has been given that level of insulation and protection, the other has not, which is the Election Commission. One tier below this, if you can imagine, one tier below this are independent investigating or superintendence agencies, the CVC, the CBI, and the ED. Your lordships had to step in. ED less so, but CVC and CBI definitely. They have their own protections as far as the federal structure is concerned. So you need permission from the state if the CBI has to investigate Section 6 of the DSP Act. But when you appoint the CVC and when you appoint the CBI director, you make advertence to a committee, and it's identical committees in both cases, a committee which consists of the Prime Minister, the leader of the opposition or of the single largest party, and of the Chief Justice of India. That committee of three is what I would suggest to your lordships can be adopted equally for this purpose also. It is independent, it appears balanced, and like your lordship said, every institution, eventually there won't be a perfect system. But you will have to look at what precedent we ourselves have set. Now, keeping these parameters in view, and these parameters in my view are important for all my issues.
Before you proceed further,
Yes.
just have a
Yes.
clearing of a certain idea. I mean,
Yes, yes,
see, when the Chief Justice, like,
Yes.
let's assume that we accept your point,
yes,
yeah?
yes,
And the Chief Justice is a member of the collegium,
yes,
as you call it, or whatever the committee you call it.
yes.
Yeah?
Committee, it will be selection
It's
committee.
a committee.
Yes,
The Chief Justice is there, leader of the opposition is there, and the
Prime Minister.
CJ.
Yeah.
Now, so what is the procedure that is usually adopted? For example, in the case of CBI,
yes,
usually it will be from the Indian Police Service
yes. That's in the statute.
in the statute.
In the statute, they provide for the qualifications, eligibility, report.
Everything is-
It's all there.
In
Yes.
the case of the election commission and the chief election commission,
Yes,
it's usually drawn from the IAS officers.
yes.
No, what is the objective material they'll go by? They'll go by the confidential report.
ACR, yes,
ACR. ACR for the whole of their lifetime,
correct,
they get outstanding.
correct.
So that there'll be a giving of the marks and some particularly
Yes.
excellent officer,
Yes,
honest. There'll be the,
yes,
will it have anything to do with his definite political leanings? Because ultimately, the man may be completely honest,
Yes,
every which way,
yes,
financially honest.
yes.
But when it comes to his political lean, we're just posing this.
Yes, yes, no, I agree, I agree, I agree.
Whether, this meeting of minds of these three dignitaries
Yes,
we have mentioned,
Yes.
Chief Justice,
yes,
because we don't know how it happened.
Correct.
Meetings, normally we take, when we also have these meetings, we go to the ACR,
correct,
there is a good officer,
correct.
that's all.
Yes,
Will it be sufficient to ensure that, it is elected as it is appointed as a chief election commissioner or the election commissioner, that he will not end up displaying complete political bias?
no, absolutely no assurance of that. And there can't be. We don't have that assurance even from the Supreme Court's collegium. We don't have it from any of these committees that we have for CBI directors, CVC. We have, your lordships have seen the number of petitions we find day in and day out against a CVC. Or in fact, in the CVC case, your lordship will remember that CVC Thomas, when he was appointed, I was with Mr. Venugopal appearing for the CVC.
We remember that.
So, no, but I'm glad your lordship mentioned that, because it brings up that additional point that your lordships evolved in that case, in that Center for Public Interest Litigation case, which was institutional integrity.
Because this proficiency, competence
Yes.
is not necessarily to be conflicted.
No, it's
with-
suitability that your lordships are at. Because,
conflicted with independence.
no, it can't. It
See,
can't.
the
So,
point is-
eligibility
See,
is,
the reason
Yes.
why a Supreme Court judge
yes,
is able to do the things
Yes.
he is able to do
yes,
in fact and in law is that he is insulated from the doctrine of pressure
yes,
under the shadow of which the government servant operates.
that's true.
Because
That's
that's
absolutely, yes,
Supreme Court judge cannot be thrown out there
yes,
if they want to,
Yes.
even if they want to.
yes,
It's an elaborate procedure.
correct.
So that is something which is may not have anything to do with his competence.
Yes,
You may have a competence, you may have a need,
no,
as
yes,
Dr. Ambedkar said.
absolutely.
So that is the area, where we are a little, we.
No, so which is why, my lords, every time, I mean, your lordships are better placed than I am. Every time your lordships have been on interview committees to appoint judges, for example, your lordships will have the basic parameter of eligibility, which are the basic qualifications, etc. But above that, there will be discretion which you will have, whether you put it down as a procedure which you must look at, or whether you don't. There is always, and there has to be, discretion available with that committee or that appointing body to say, let us look at quality of his judgments. Let us look at his deport. Does he lose his temper in court when you're appointing a judge, for example? So similarly with this, surely there would be a methodology which would be available for you if you know that, look, lots of decision making which has not been independent in whatever post he held. As a secretary, he was supposed to take action, he took action against only people.
The second follow-up question also
Yes.
is relevant.
Yes,
You see, it is perhaps, we have to be sort of a little personal.
yes,
It's part of history.
yes,
The Election Commission of India perhaps is the envy of the world. This is one institution which has come in for a lot of compliments.
of course.
It's
a massive act.
particularly after a particular individual took over.
Yes,
We all know
Yes,
that. It's
yes.
the TN station.
yes,
Call him sort of very despotic, as some people. Back to the matter is that he mustn't just wait.
yes, left his mark.
The question is this, something slightly different. What perhaps Asian succeeded in doing was putting in place a lot of mechanisms in the form of rules, how the commission, because it's the election commission,
Yeah.
maybe the chair of the election commission alone or with the assistance of the, as held in Sessions case.
Yes,
Whether it is more important that, that the discretion of the election commission, as my brother put to the question, is reduced to the minimum. Because discretion power is inevitable.
yes,
You will have power.
correct,
So how you respond to a particular situation, political party comes,
correct,
do this.
yes,
You have a set of rules which, if they are followed,
yes,
you will eliminate this, this fear that you will be dependent on the powers that we will act in,
of course,
sort of foster their interests.
yes,
So is that as important as also the persona, the person's attitude, his independence, his character, competence?
I think for way too long, and this is again, since your lordship mentioned this, I think for way too long there have been positions which at the beginning, at the time of independence, I think people who populated those constitutional positions were well aware of the strength and the level of independence available in those constitutional positions. Unfortunately, in days that have come, we have seen those positions not being not enhanced, but being exercised in the manner in which it can be to its fullest. Many of these gaps that your lordships have been filling up, particularly in electoral reforms, your lordships have seen so many cases in which you've filled up gaps. Those gaps didn't need to be filled up by this court. With the greatest of respect, the Election Commission had the power, just like they passed the symbols order. They could have passed a series of orders which 324 permits them to do. Superintendence, direction, control. 3 words which vest in them the widest of powers to ensure that these loopholes are fixed, but they didn't do it. Either they don't recognize the extent of their power. I think after your lordships have repeatedly said this over 30 years, from Sadiq Ali onwards, I don't think there was a doubt. Even in 52 in Ponuswamy, your lordship, 6 judges made it clear about how this part is almost like a complete code, the wide powers that are available. Now, considering that, we have seen that the individuals who have populated these posts have not exercised the powers which are available. If they have not exercised it, and it's fairly manifestly evident that those powers are there for them to exercise it, there must be something that we can't see. Occasionally, we get glimpses of. Occasionally, like the Election Commissioner Naveen Chawla's letter, which I enclosed in the counter affidavit, he mentions that, look, Mr. Session did not get along with Mr. Gill and Mr. Krishnamurthy, so he tried to stymie that, and fortunately the court has held in our favor. He says there was a recommendation now to remove me by the CEC, and the court has, the government has rejected it, so thankfully I'm here. Here are some reforms I suggest. So they're always having this pressure, this knife hanging over their heads. So it's very difficult for us to estimate the extent of that. We are standing on this side. I have no clue. We cannot try and inform your lordships or apart from what has come out. And there are many instances. I'll give your lordship one more example.
Come out with any mechanism as on today, will they follow in making appointments?
Not that the government will have to tell your lordships. Not that we know.
In your petition, you must have questioned, and their response is there.
We have said that there is no.
Filed the response also.
Yes,
they filed the response.
They filed a counter.
So what we are requesting you is, have they come out with the mechanism they have adopted in making appointments?
In my petition, the appointment process was not in my prayers, as your lordship have seen. My last prayer is a wider one. I'm presuming it must be in one of the other petitions what their response is. But since we don't have a law, we don't have rules, it's definitely not in the constitution. We don't know what the process is. The appointment eventually is by the president. As judges appointment by the president eventually. It's his warrant. But the process that is followed.
You want to know the process. Appointment maybe by the president.
Correct. So
but we are concerned with the process.
Yes. But what we are presuming, and the basis on which we are proceeding, is that it is following Shamsher Singh, Westminster form, the government, the cabinet recommends a name and the president goes ahead and puts his. If it's a president acting on his own, I gravely doubt it.
Rules of business.
Yes.
Under the rules of business under 77.
Yes.
Probably they might have some.
They may perhaps have that.
Ultimately, it's a council of ministers.
Yes, ultimately it's a council of ministers, my understanding. If it's something else, I could be corrected.
Purely executive.
Yes.
Nothing much about it.
One other thing I wanted to touch upon is that very often we have seen that election commissioners or the election commission, if there is governmental influence on the election commission, a decision which should be taken immediately, should this symbol go to that party or this party, will take months. Something we have found with speakers of the various houses as well.
And political bias.
But yes, that political bias.
Political bias, independence.
Correct, but the political.
What you're saying is, how
Yes.
do you actually get somebody
Yes.
who will be above politics?
So
who's not partisan.
Correct. So
even if you get the best of people.
Correct.
Most neutral a person.
No, I agree. So what
select, because the process is the ACR.
Yes. So in my view, you have to start at the top, give them independence when they are appointed, give them protection during their tenure, make them recognize the extent of their powers, and ensure that any assault on any one of these three is strictly checked. We are at stage one, at the process of appointment. It's still not something that will be a complete.
We're concerned with that.
Yes.
We're concerned with that.
That protection is there. Written,
Only for the,
five.
only for
Five
the,
provides.
only for the CC, but not the election commissioners is what has been.
That's right.
I want to interpret.
Observations in session.
In session. I just want to reinterpret that.
That's right.
Yes.
That-
And Gopal, keep one thing in mind.
Yes.
Merely certain incidents which are brought to notice or brought to
Correct.
light
Correct.
by the media.
Correct.
That may not be determining.
It cannot be. It should not be, which is why we are not even telling your lordship.
Because these things are bound to come.
Correct.
But these mere instances brought by the media to the public consumption,
We are not even
that
relying.
can't be a ground
Not
to
at all.
intervene and interfere.
No. We are not even relying on it.
These are the phases bound to come.
Correct. So we are not relying on that. That's all anecdote. But when your lordships left,
Keep
go ahead.
look at the clock also.
I will. I'm doing that.
So.
No, because it's a very, very important question.
That's right. We are not saying that.
You know, we
but
keep knocking on your lordship's doors and eventually we get a hearing before Constitution Bench. We understand the gravitas and we must assist your lordships in the fullest fashion. You will pardon us if we sometimes are over anxious.
That's right. We are
And force you to read too much.
We will certainly not sort of crib your time, but then just bear it in mind.
No, absolutely.
In this part.
So I have towards that end, my lords, I've tried to make it simpler for your lordship. I will just take your lordships to the index of that compilation, that convenience compilation. Just take the first volume index. And I'll tell your lordships what I'm relying on from it.
Yeah. Yeah.
If you just see that common compilation, that index, item number 5. This is to directly answer Justice Joseph's question to me about how that appointment takes place at the moment. Because I've just, Mr. Bhushan's instructing lawyer has been kind enough to share with me the reply that they have filed in the other affidavit. And they make reference to this. If you just come to that page 94, that's the transaction of business rules, and Article 77.
That's right.
Just 2 pages are relevant. 98. Page 98.
Yeah.
Not Justice Rastogi has it, first volume.
Page 90.
98. Rule 8. This is part of the transaction of business rules. 8 is submission of cases to the Prime Minister and the President. All cases of the nature specified in the 3rd schedule to these rules shall, before the issue of orders thereon, be submitted to the Prime Minister or to the President or to the Prime Minister and President as indicated in that schedule. Well, also we come to page 116, 116. The schedule starts at 115, the 3rd schedule that's referred to. 116, please mark item 22 on that table, page 116. That's appointment, resignation and removal of the CEC and the other election commissioners. They trace it to 324 and the authority to whom to be submitted is the Prime Minister and the President. Your Lordships will find item 12 deals with the judges. References Supreme Court is 13, CAG is 14. So similarly, 22 is this. So this doesn't lay down the process for appointment. It's merely saying this is how we transact a business, this is how it will proceed. Then in that index again, another question that fell from Justice Joseph was about the 1991 Act. So that is item number 7, not the GNCTD Act, that's item 6, also 1991, but the item 7, the Election Commission, Condition of Service of Election Commission and Transaction of Business Rules, which starts at page 151. It's just 3 pages.
Few pages.
Yes, 2 pages, 2.5 pages effectively. Your Lordship may see it. Page 152 makes it clear that it's an act to determine the conditions of service of the CEC and other election commissioners. They made an amendment to include the election commissioners also, made mandatory. And it provides for salary, term of office, which is 65 or 6 years, leave, pension, and other conditions of service. Again, doesn't deal with how they are appointed. What this was relied upon in session is to show the parity between the CEC and the other 2 members.
Relates to Article 324(5).
324(5), absolutely. And that there is no distinction between them, at least here. They are treated on par for all purposes. This will be relevant only for the limited purpose of the second argument I will make with reference to putting them on par, giving them protection. Then back to the index, my lords. Your Lordships may just note item number 9 is that Goswami Committee report. Specifically pages 436 to 440. If I can ask your Lordships to just jot down 436 to 440, which is the setting up of and securing the independence of the commission,
That's been done in the endorsed
By-
by the 255th
law commission report as well.
Yes.
Yes. Then I think just partially, I don't think it's really relevant, but taking off from Justice Rastogi's question, item 21 in that index.
21.
Yeah.
That's a article.
It's an article, it just lists out at page 1022. And Justice Rastogi said we can't go by it. I'm not going, but I'm just mentioning that there have been a series of instances which are mentioned. In this, you don't have to trouble yourself. It mentions how they believe that these election commission's activities in a series of cases, and they've traced out date, time, etc., where the credibility of the election commission may have been undermined or damaged, etc. Just instances. Then among the judgments, which is the third volume, just again once, please go by the index itself. I'll advert to it. I don't want to trouble your lordship reading too many paragraphs. Item number 23. Indira Gandhi versus Raj Narayan. Sorry. Because I'm still using the index only of the first volume.
So there's a
Same common index.
serial number you can give. So that
I'm just giving the serial number. Serial number 23 is Indira Gandhi versus Raj Narayan. Paras. Sorry.
Yes.
Yes.
Which page?
In the index itself.
No, in the index somehow.
Oh, it's
Wrong
so sorry.
page as
Just the
well.
first volume. Your lordship has the index? No.
No, we.
Oh, I'm so sorry.
First volume is a complete.
No, I think my lord's copies. Second volume. My lord's copies don't have it.
Same page.
First volume has the full index. Oh, yes.
Sorry, yes.
Sorry, that's the first volume's index. It has the index for all three volumes.
Yes.
So item 21 is what I just referred to, list of instances in the caravan article. Then item 23 is Indira Gandhi. Your lordship may just note there itself, paras 213 and 239 and 345.
Yeah.
Then Mohinder Singh Gill, which is the immediate next one.
24.
Well, a few others. Third paras 12 and 39 to 41.
39 to 41.
39 to 41.
Yes.
There's also concurring minority, which has conclusions of the majority are at 92. Then minority 105 to 107 and 113. Then Manoj, item 26. Kanhaiyalal is paras 9, 16 and 17.
Para 9.
16 and 17.
Yeah.
Sensation, there are a series of paragraphs, I'll read that for us, but it's largely 10, 11, that's item 29, I'm sorry. Item 29, PN session. 10, 11, 16, 18 and 19. Item 31, special reference, that's paras 27, 75 to 77, and para 80. And item 32, Association for Democratic Reforms, para 45.
Yeah.
Manoj. Now, Manoj, I'll just address briefly on these 4 points that I want to address. The first is with reference to the committee for appointment. Your lordships have, and I'm using this parallel, the parallel which has already evolved and exists for 2 sets of institutions. For the judiciary, that parallel started with the second judge's case, the creation of the collegium, its re-emphasis in the NJC judgments, NJC judgment, Malaj, is not part of this compilation. That's Supreme Court Advocates on Record Association. That's 2016, 5 SCC, page 1. These judgments together, and I may read one or two paragraphs, but these judgments together, I mean, the Lordships have all read this many, many times, effectively say, apart from interpreting words in the Constitution, consultation meaning concurrence, creation of a collegium, a fact that doesn't exist in the Constitution, but created as a mechanism to take the constitutional goals to a particular end, an end which is independence of the judiciary. There is a very clear parallel there, and the emphasis has come back by saying independence of.
I think a compilation contains the judgments also.
In not NJSC, not the NJSC judgment, but your Lordship may not trouble yourself, not this kind. I just broadly set the framework. Therefore, what are the things that are required for me to draw this parallel? One, there has to be a fundamental norm which goes to the ethos of the Constitution. Independence of the judiciary there, free and fair elections and democracy here. A vacuum which exists in the Constitution with reference to process of appointment. There was a particular kind of process where the may even now, as the government does make arguments saying that really there is no vacuum, interpretation shouldn't have been made. In this case, there's a very clear vacuum. There's nothing in the Constitution which assesses on how that appointment will take place. Third, the kind of roles that are discharged by these institutions. Is it a role which is independent? Is it a role which provides a very integral check and balance into other institutions? Which I don't think we need to regurgitate the fact that that is true of the judiciary and it's true of the Election Commission. Many of these judgments and those citations I've given your Lordships, particularly MS Gill and that Gujarat special reference. Those two judgments, as far as your Lordships will read, will tell your Lordships how the powers of the Election Commission are wide, the powers of the Election Commission are of a nature of high sanctity within the constitutional structure. If that is so, and that holds true for the judiciary, the same level of protection, ironclad protection, is required for them as well. And I am completely in agreement with what fell from Justice Rastogi. We won't go into instances. Let's keep this completely clear of instances. You may have great individuals, like Dr. Ambedkar said in his closing speech in the Constituent Assembly. Finally, it is about the people and their character which will drive the institutions under this Constitution. So you may have excellent chief election commissioners and election commissioners. You may have weak ones. You may have ones who are influenced. The idea here is not to look at the individual, but to look at the institution and to say, let us have a system in place which will insulate and protect that institution from the vagaries of the political class, from the vagaries of a ephemeral executive that will come into the saddle based on a bunch of votes at a particular point of time. If that is so, this one parallel, which you also will find with the second judge's case and what is now the fourth judge's case, is one. The second parallel to that, and which is why I'll trouble your Lordship with the book, is Vineet Narayan. Because Vineet Narayan's history, even though it came from the Jain diaries and it having come from a terrorist who was arrested, etc., it took a completely different direction. If your Lordship will have that judgment, this deals with the other institution, the CBC, the CBI director, excuse me, and the director of the ED. This is 1998, 1 SCC, 226. It's not in the compilation. 1998,
226.
1 SCC, 226. Mr. Anil Devan was the amicus in this case. And recently there's a foundation in his name with Sham Devan and others, and they've started a series of very interesting podcasts where they discuss each case, each 2 or 3 important cases of Mr. Anil Devan's life. They've started with this, and it's a long 45-minute podcast dealing with many aspects of the history of this case, how it evolved, how it went through, and what its influence has been in the years that have come. If your Lordship will see para
I don't
26.
think you are in practice when Mr. Anil Devan was in active practice.
I have instructed him as well. I'm not that young.
I've seen him.
Yes. Para
Independent taxations.
No. A very fiercely independent man. He appeared for Mr. Ramjet Manani and Ramjet Manani in the black money case. And they used to, it was fascinating for young lawyers like us to see the two of them, client and lawyer, loudly arguing. And Mr. Devan, I remember in this very courtroom once saying, I'm your lawyer, you keep quiet.
There's a bit of a Mr. Shankar Nayak.
Yes.
This was during the end years of Mr. Diwan's life.
Yes.
He was on a wheelchair.
Yeah.
I had gone to the Akshara Theatre
Right.
near Aramal.
Yes.
So he was brought in a wheelchair because it was in commemorative Jalabala Vaidya and Gopal Sharma. So, of course, I said hello to him. I was a judge in Guwahati. And if you visit Akshara Theatre, you mentioned 2 persons.
Yeah.
On the left-hand side of the wall, Ram Jethmalani's name is written there. So he must have sponsored
Oh, you must have.
the
Yeah.
creation of that theatre. Jethmalani and Anil Devan, I mean, when he was perhaps not able to move, he had gone to watch a performance.
Fantastic. Well, it's good to have that kind of balance. Mr. Ashok Desai used to keep telling all youngsters that don't just immerse yourself in law books, get into culture, read fiction. Very important.
Yes.
So it's para 26 of this. 26, the page 255. This is dealing with the internal committee that had been set up. If I can just read this part. The IRC is a body constituted by the central government itself as a result of its perception that the constitution and functioning of the CBI, CVC and Directorate of Enforcement require a close scrutiny in the background of the recent unsatisfactory functioning of these agencies with a view to improve their functioning. The view taken by the IRC is a reaffirmation of this belief shared by everyone. The preface to the report indicates the reason for the constitution of the IRC and says that in the past several years, there has been progressive increase in allegations of corruption involving public servants. Understandably, cases of this nature have attracted heightened media and public attention. A general impression appears to have gained ground that the central investigating agencies concerned are subject to extraneous pressures and have been indulging in dilatory tactics in not bringing the guilty to book. The decisions of higher courts to directly monitor investigations in certain cases have added to the aforesaid belief. There can thus be no doubt that there is need for the exercise we were called upon to perform, and which has occasioned consideration of this crucial issue by this court in excess of its powers conferred by the Constitution of India. The conclusions reached by the IRC and the recommendations it has made for improving the functioning and thereby the image of these agencies is the further reaffirmation of this general belief. There can also be no doubt that the conclusions reached by the IRC and its recommendations are the minimum which require immediate acceptance and implementation in a bid to arrest any further decay of the quality. It follows that the exercise to be performed now by this court is really to consider whether any modifications or additions are required to be made to the recommendations of the IRC for achieving the object for which the central government itself constituted the IRC. We are informed by the learned Attorney General that further action on the part of the IRC could not be taken so far because of certain practical difficulties faced by the central government, but there is no negative reaction to the report given by the central government. Now, this is the background, Manoj. Please come to para 49. Dealing with the powers of this court. 49. 48 I'll take as read, Manoj. 49. There are ample powers conferred by Article 32 read with Article 142 to make orders which have the effect of law by virtue of Article 141, and there is mandate to all authorities to act in aid of the orders of this court as provided in Article 144 of the Constitution. In a catena of decisions of this court, this power has been recognized and exercised, if need be, by issuing necessary directions to fill the vacuum till such time the legislature steps in to cover the gap or the executive discharges its role. It is in the discharge of this duty that the IRC was constituted by the Government of India with a view to obtain its recommendations after in-depth study of the problem in order to implement them by suitable executive directions till proper legislation is enacted. The report of the IRC has been given to the Government of India. Because of certain difficulties in the present context, no further action by the executive has been possible. The study having been made by a committee considered by the Government of India itself as an expert body, it is safe to act on the recommendation of the IRC to formulate the direction of the court to the extent they are of assistance. The remaining area, on the basis of the study of the IRC and its recommendations, suitable directions can be formulated to fill the entire vacuum. This is the exercise we propose to perform in the present case, since this exercise can no longer be delayed. It is essential and indeed the constitutional obligation of this court under the aforesaid provisions to issue the necessary directions in this behalf. We now consider formulation of the needed directions in the performance of this obligation. The directions issued herein for strict compliance are to operate till such time as they are replaced by suitable legislation in this behalf. Para 51 lists out the various cases where directions, this is before 98, all directions have been issued with reference to the guidelines under immigration, foreign adoption, of course, Vishakha and others. Vishakha is laid down, the extract is there on the following page. And para 52, as pointed out in Vishakha, it is the duty of the executive to fill the vacuum by executive orders because its field is coterminous with that of the legislature, and where there is inaction even by the executive for whatever reason, the judiciary must step in excess of its constitutional obligations under the aforesaid provisions to provide a solution till such time as the legislature acts to perform its role by enacting proper legislation to cover the field. On this basis, we now proceed to give the directions, etc. Para 54 is interesting because your lordships adopted these standards in public life. It is a similar perception in England, para 54, which has led to the constitution of a committee headed by Lord Nolan on standards in public life. In volume 1 of Lord Nolan's report, the general recommendations made are, and they have laid down the 7 principles, small number 5 if your lordship sees, principles of public life. The general principles of conduct which underpin public life need to be restated. We have done this. The 7 principles of selflessness, integrity, objectivity, accountability, openness, honesty, and leadership are set out in full on page 14. Codes of conduct which should be drawn up by all public bodies, independent scrutiny, education. Then these 7 principles are laid down below for those who hold public office. And para 55, the court says, these principles of public life are of general application in every democracy, and as one is expected to bear them in mind while scrutinizing the conduct of every holder of a public office. It is right that the holders of public offices are entrusted with certain powers to be exercised in public interest alone, and therefore the path is held by them in trust for the people. Any deviation from the path of rectitude by any of them amounts to a breach of trust and must be severely dealt with instead of being pushed under the carpet. If the conduct amounts to an offence, it must be promptly investigated, and the offender against whom a prima facie case is made out should be prosecuted expeditiously so that the majesty of law is upheld and the rule of law vindicated. It is the duty of the judiciary to enforce the rule of law and therefore to guard against erosion of the rule of law. Well, it's para 58, eventually, the directions that they give. The first direction is important because it's the first time, despite judgments in the past saying courts don't give directions for framing of statutes, the lordships gave a direction that the Central Vigilance Commission shall be given statutory status, which it was given in compliance with. One previous instance was in Indra Sawhney, where lordship said that the National Backward Classes Commission should be formed for deciding addition and removal from the list of backward classes. There also the Parliament effectively complied by passing such a law, the National Backward Classes Commissions Act. Now, the whole swath of directions, a large part of this based on the recommendations of the IRC, another part dealing with recommendations of the Amicus Curiae as well. So the first one is dealing with CBI and CBC. And the second, which starts at page 271, deals with the Enforcement Directorate. And one interesting part of these directions is that both in this case,
Mr. Shankar,
yes,
this direction has to be given in a collaborative proceeding.
absolutely, absolutely,
Because legislative exercise is on the basis of majority rule in parliament.
absolutely, absolutely. There's no running away.
Because we direct, frame a law.
Correct,
We
correct.
can't say
Yes,
all the MP should vote in a particular way.
absolutely no, absolutely no. I don't think the court did that either. I think this is the court's way of recommending that please give it statutory flavor.
Yes.
Because that's the only way you can really have it.
Executive direction also.
Yes, and it's a sign of cooperation that the government did.
This is a collaborative.
Absolutely, absolutely, completely collaborative. It was not, there's no question of a mandamus being issued, sir.
What led to it is para 50. So what was the background where the court took a view that why do we need to get into in this mode if para 50?
Yes, I'll read that. I'm reading. There is another aspect of rule of law, para 50, which is of equal significance. Unless a proper investigation is made and followed by an equally proper prosecution, the effort made would not bear fruition. The recent experience in the field of prosecution is also discouraging. To emphasize this point, some reference has to be made to a large number of prosecutions launched as a result of monitoring by the court on this matter, which have resulted in discharge of the accused at the threshold. It took several years for the CBI to commence investigation, and that too as a result of the monitoring by this court. It is not as if the CBI, on conclusion of the investigation, formed the opinion that no case was made out for prosecution so that the earlier inaction may be justified. The CBI did file numerous charge sheets which indicated that in its view a prima facie case of prosecution would be made out. This alone is sufficient to indicate that the earlier inaction was unjustified. However, discharge of the accused on filing of the charge sheet indicates, irrespective of the ultimate outcome of the matters pending in the higher courts, that the trial court at least was not satisfied that the prima facie case was made out of the investigation. I'll just skip the next few lines. This is the occasion for us to take the view that a suitable machinery for prosecution of the case filed by court by the CBI is also essential to ensure discharge of its full responsibility by the CBI. Unless a competent prosecution follows a fair and competent investigation, the exercise and the ultimate analysis would be futile. Investigation and prosecution are interrelated, and improvement of investigation without improving the prosecution machinery is of no practical significance. We would therefore consider the aspect of prosecution also in the formulation of guidelines. But one of the things that arose here was that when sanction was being given for prosecution, they would drag their feet because the officials who were actually carrying out these instructions of their masters would then be protected because you wouldn't give sanction for prosecution. So Vineet Taran said 3 months, and it was reiterated in Subramaniam Swamy versus Manmohan Singh in the arising out of the 2G case, where they said that 3 months is the limit on sanction for prosecution. So these are all small vacuums also, which your lordship have been forced to fill up. And in domains where you imagine and anticipate at the outset that, look, if somebody has committed an act which is a crime and he claims that it is in his duties, you will take a decision, both under 19 of the Prevention of Corruption Act and 197 CRPC, of giving sanction, but you decide not to give sanction. One more example was more recently in Kesham Meghachandra, which is the judgment authored by Justice Nariman on speakers taking their own sweet time about giving a decision about a disqualification of a member of the assembly, where the court said 3 months again. So your lordships have at every instance attempted to fill these gaps, saying that, look, we expect you to function in a proper manner, but if you're not doing it, then we have to fill those gaps. So 3 months in Vineet Taran, 3 months here, where you would not imagine, and your lordship can anticipate the arguments that come on behalf of the states in those cases, saying it's the speaker, you can't possibly tell the speaker to take a decision. But eventually democracy has to move on.
These 3 directions in reference to CBI director and all,
Yes,
running from page 269,
yes.
it is still in place, or
There have been small tweaks.
there
There have been small tweaks. So I'll just tell your lordship.
why we are asking is,
Yes,
you come to the CBI director,
yes,
this court has an occasion to lay down the minimum criteria also, and eligibility also.
yes, yes.
Now, the court has not left only that a person should be considered credible nature. No,
No,
there's a qualifying must be this, he
Yeah.
must be civil servant, this,
Yeah.
this. So there are
Yeah.
certain conditions of service like which the rule making authority lays down
correct,
have also been prescribed by this court.
correct. But that's because there was a,
Because in our constitution 324(2),
yes,
there is nothing like
there's
that.
nothing. There is nothing.
Now, presumption is they may appoint a civil servant. They can appoint anybody else
They could,
or man of their satisfaction,
yes,
which may
absolutely,
fulfill their guidelines and criteria, whatever it is.
absolutely.
But this court has intervened, laying down the conditions. What are the eligibility
Yes.
conditions for the men to participate?
Yes, and that eventually was engrafted into the Delhi Special Police Establishment Act, the DSPE Act. I don't know if your lordships have it, the Delhi Special Police Establishment Act. Yes, couple of sections.
These very conditions have been incorporated.
Yes.
Actually, this
But there was an amendment, I'm sorry.
Lord Nolan's principles,
Yes, no.
you have referred that which we approve the appointment,
Yes,
you have referred what will be the salary,
correct.
but there's no mechanism in place which will inspire confidence of all that we are able to select honorable men. And there I must say also honorable women. Why women
Absolutely.
are missing from the
Absolutely.
consideration
Absolutely.
for the post of Chief Election Commission?
Yes,
This is something which is a little disturbing. I would
yes,
say.
yes. We've never had one.
But this
We haven't had.
but these are gender neutral.
No, they are gender neutral, but somehow we
Yes.
have not found a
We have-
honorable woman.
That's correct.
Yes. That's, in fact, the author of one of those books is Ms. Rama Devi. The lordships would find those commentaries on, who used to, I think she was governor at some point. And that's been a huge loophole. Your lordships are absolutely right. And but I don't think we've had a female CVC either,
That's right.
or CBI director or ED director. It's always been men.
But we have had very fine officers. I mean, if you have to look at the cadre of officers, we've
Of
had
course, of
very
course.
officers of very fine distinction.
Maybe if we had more women at the helm in all those situations, we wouldn't be here. I have 6 associates, all women. And I must tell your lordships.
That has nothing to do with the good look of the senior.
No. Oh, if only my wife heard that. Well, it's, the two legislations, I think, which would apply, again, the other parallel, apart from the judiciary, SCORA, etc. One is the DSP Act. Now, the recommendations came, the DSP Act was amended. It was amended a second time, and that was in 2014. So I'm not sure if your lordships have the DSP Act. If you have the, I'll just read out the section. It's section 4A, B, BA, and C, which were inserted, capital A. So section 4, capital A now reads, the central government shall appoint the director on the recommendation of the committee consisting of A, the Prime Minister, B, leader of opposition recognized as such in the House of the People, or where there is no such leader of the opposition than the leader of the single largest opposition party in that House, and C, the Chief Justice of India or Judge of the Supreme Court nominated by him. Subsection 2 says, no appointment of a director shall be invalid merely by reason of any vacancy or absence of a member in the committee. And 3, the committee shall recommend a panel of officers on the basis of seniority, integrity, and experience in the investigation of anti-corruption cases. And B, chosen from amongst officers belonging to the Indian Police Service constituted under the All India Services Act for being considered for appointment of the director. So as of now, none of us have made submissions, or I don't think we've anticipated such submissions to be made on the kind of individuals who need to be selected as election commissioners, chief election commissioners, etc. We have, I think, we've been in a bit of a stupor because we have had this custom for so many years that it's usually former secretaries to government who are appointed as election commissioners in a large part.
Judgment for appointment of chief secretaries in the state and director general of police in the state respectively. So you have to send a panel of 3.
Yes.
The UPSC also
That-
examine it and then they send the list to the
UPSC.
state,
Yes.
leaving the discretion to a very limited scope.
Correct. And that your lordships have stepped in. In Prakash Singh, you stepped in for the police. And in TSR Subramaniam, you stepped in for the IAS. So both those judgments are there. Prakash Singh, of course, in contempt now. 1996 petition, 2006 judgment, 2016
10 also.
contempt petition. Yes. So and now series of contempt petitions. And we have had interim orders of the court in Prakash Singh saying that now this will be treated as law, and if any law is made by any state legislature which is inconsistent with Prakash Singh, that will have to give way. Because they've tried to undermine what your lordships have laid down. So, Manoj, 4A is a committee that I would recommend. This is where I'm slightly standing a little apart from Mr. Bhushan. Mr. Bhushan said that you can't have either the majority party or the minority party involved. I believe it's a system we have. We could try something a little more expansive, I suppose, which is what we have in the Lokpal Act. That's another alternative. But what I would recommend is we have this one which is tried, tested, but not in the ideal fashion, I suppose. And if you lordships take the Lokpal Act, section 4, I'll just read that out. Section 4 again, this is 4.1.
You call it only Lokpal Act.
It's called the Lokpal and Lokayuktas Act 2013. So I'll just read out that. I don't want to trouble your lordship. The chairperson and members shall be appointed by the president after obtaining the recommendations of a selection committee consisting of. So please note, appointed by the president, like in 320. After obtaining a recommendation of a selection committee consisting of A, Prime Minister, who will be chairperson, B, Speaker of the House of the People, who is a member, C, Leader of Opposition in the House of the People, who is a member, D, Chief Justice of India or a judge of the Supreme Court nominated by him as a member, and E, one eminent jurist as recommended by the chairperson and members referred to in clause A to D above to be nominated by the president. Yeah. So this is larger. This is 5 members, and the 5th member would be appointed by the other 4. My submission, my lords, is that there is clearly a vacuum there's clearly a vacuum in Article 324(2), because it says the election commission shall consist of. So it's informing us of what the election commission consists of. The chief election commissioner and such number of other election commissioners, if any, as the president may from time to time fix, and the appointment of the chief election commissioner and other election commissioners shall, subject to the provisions of any law made in that behalf by Parliament, be made by the president. So, if the law was made by Parliament, then this part of the provision that the appointment would be made only by the president, broad, ipsy dixit, whatever it is.
Have you checked in state election commissions?
I'm sorry, ma'am?
In state election commission.
Yes, ma'am. About that?
Any state has come out with any kind of a form, guidelines in making appointment?
I'm not sure. I would not be able to assist on that at the moment.
Make a research on it. Any state.
I'll find out.
Mechanism is almost the same. Goes on.
Yes.
So if
But that's under the Act, Manoj.
yeah, that's correct. But they laid out any guideline for the purpose of qualifying and the mechanism for making one.
Representation.
You please check it.
I'll just tell you that.
Any state is coming from.
The 1950 Act.
Fortunately, not even the state commission was comes under the constitution, and there are no.
No guidelines. No. But state can have its own rules and regulations in place.
Guided by the constitution.
That's correct. That's correct. But you see, he's saying about the parliament here, but he can say for the state also. In state also they have some mechanism.
I can say this with regard to Delhi, NCT, because
Delhi is one.
Because what we do is, for the state commission, we take the entire rules and regulation parameter to the municipal elections and we follow that. In fact, to an extent that we take the electoral.
The Lokayukta Act in 2 states, Karnataka and Madhya Pradesh. It's quite different than this act in other states. No other state want to follow that.
We have a centralized. We have rather a centralized system as regarding the state election commission. It is rather centralized in the country. unlike US or UK, we have a centralized system. Very often state commissions can only act rather in as a subordinate to the central system. That is the system.
1950 Representation of People Act. In section 13A, deals with the chief electoral officers in each of the states. And it provides that there shall be for each state a chief electoral officer who shall be such officer of government as the election commission may in consultation with that government, with that state government, designate or nominate in this behalf, subject to superintendent's direction and control of the election commission. The chief electoral officer shall supervise the preparation, revision and correction of all electoral rolls in the state under this act. And then district election officers, electoral registration officers, etc.
So state electoral officer and state election commission same?
No, I'm presuming that he would
May
be.
I just clarify?
Yeah.
Because there are two parts in state. One is the chief electoral officer. He represents Election Commission of India because we have state legislative assembly elections also. So he is the representative for Election Commission of India in a particular state. Then, as my lord said, that there is a state election commission. Now, that state election commission has nothing to do with the state legislative assembly election or
For
parliament.
the municipal election.
Please, brother.
No, you
They have a separate setup. They have separate
No,
act.
we want to know from you, any state has developed any mechanism transparent for the purpose of making an appointment of a state election commission?
There is no the separate state elect.
There is state election commission.
There are acts.
Yeah, for the purpose of elections in the state municipal.
That's what. Yes, there are separate acts.
We want to know if they have make any mechanism for appointment.
Yes,
Or they also go on with the consultation.
just to clarify.
The discussion also will open up in the council assembly. And the legislative way of talking to everything.
Yes. So the
243K, capital
part.
K, talks about the state election commission.
Or not for the purpose of state legislature.
Yes,
No, not the state legislature.
That is vested with the central.
That's central.
That's why there is a split between two parts. Where the union election and the state assembly elections are concerned, that goes under 324.
Absolutely.
So far as the state panchayat bodies and the other municipal bodies are concerned, that comes under because that goes in the list too. And therefore there is a separate act created for that.
That's 324K for 243K, for example, says
Yes.
superintendent's direction and control of the preparation of electoral rolls for and the conduct of all elections to panchayats shall be vested in a state election commission consisting of a state election commissioner to be appointed by the governor.
That's for municipalities and panchayats.
Yes, municipality. This is. My associate has just taken out Orissa rules under 243K. Rule 3 says no person shall be, I'm sorry. Rule 3 of the Orissa rules says no person shall be qualified for being appointed as the commissioner if he is not state election commissioner. If he is not a retired judge of the High Court, a retired district judge, a retired civil servant, or a serving civil servant. So they've given these 4 categories. And they say if a person immediately before his appointment was under employment as a civil servant of the state or central government, he shall be deemed to have demitted his office as such with effect from the date of his appointment as commissioner. So I'll just analyze and see the other states and what rules they have. So these are the points I'm making. 1, 324(2) as a vacuum because it does not tell us the process or the methodology or the constitution of the election commission, of the CEC or the election commissioners. There may be other vacuums in the constitution, but this is a very important vacuum because it is dealing with what is a fundamental aspect of our constitution. Two fundamental aspects. One, free and fair elections, and two, democracy. Both are linked, but your lordship have used different expressions in various judgments, so I'm attaching importance to both. 3, there has been 2 sets of precedent with similar institutions where your lordships have filled the vacuum. One, the judiciary in affording them protection. Second, with reference to the CVC and CBI, where your lordships have stepped in. For how to fill that vacuum, our recommendation is that it should be by way of a selection committee, and a selection committee which will either have 3 members like I am suggesting, which is adopted from the CBI, which is of the Prime Minister, the Leader of the Opposition and the Chief Justice or his nominee, or like in the Lokpal, have the Prime Minister, the Leader of Opposition, the Speaker, the Chief Justice and a 5th member that they will among them select. Either of those options would, in our view, serve public interest, primarily because at this stage in our constitutional system, it's important that we have institutions which are independent, and there is substantial precedent for this. Now, the 2 specific judgments, specific paragraphs I wanted your lordships to read before I close on this point. The first is Indira Gandhi versus Rajnarayan, which is in this volume. It will be the 3rd volume of the compilation. It's at page 1096.
Brief.
You have given us 4 volumes.
3 volumes.
3 volumes. But the sheet is common. The sheet of the first volume is pasted on all the volumes.
Oh,
So the pagination of digital pagination doesn't.
I'd be very happy to blame my friends on the other side who are the ones who created the compilation.
It's available in volume 1, Lordship. The index is available in volume 1.
That's correct, but the page pasted here is the same.
We take the blame, but I've been told there's at least a volume number mentioned somewhere.
That's the volume number is mentioned.
Take the blame.
So Gopal is right, so was mentioning volume number and then asking us to go the page. Volume 3.
Volume 3. Well, I'm just taking your lordship immediately to 2-3 specific paragraph. Page 1215. 1215 is para 213, Justice Khanna's. Para 213. Para 213, if I can read that. As a result of the above, I strike down clause 4 of Article 329A on the ground that it violates the principle of free and fair elections, which is an essential postulate of democracy, and which, please mark essential postulate of democracy, and which in its turn is a part of the basic structure of the Constitution, inasmuch as 1, it abolishes the forum without providing for another forum for going into the dispute relating to the validity of the election of the appellant, and further prescribes that the said dispute shall not be governed by any election law, and that the validity of the said election shall be absolute and not consequently be liable to be assailed. And 2, it extinguishes both the right and the remedy to challenge the validity of the aforesaid election. Well, then, page
Continue.
Yes, well, it's page 1259. I don't know how much this passage will particularly weigh with the presiding member of this bench. Para 345 minutes, Justice Matthew. I'll just read the para. I think the inhibition, because Your Lordship, there were two challenges here. One was the Constitutional Amendment 329A4. The other was the insertion in the 9th schedule of the Act. Para 345. I think the inhibition to destroy or damage the basic structure by an amendment of the Constitution flows from the limitation on the power of amendment under 368 read into it by the majority in Bharati's case, because of the assumption that there are certain fundamental features of the Constitution which its makers intended to remain there in perpetuity. But I do not find any such inhibition so far as the power of Parliament or legislatures to pass laws is concerned. This is basically laying the foundation for the fact that you don't use basic structure to test legislation, you use it only for constitutional amendment. Article 245 and 246 give the power and also provide the limitation upon the power of these organs to pass laws. It is only the specific provisions enacted in the Constitution which could operate as limitation upon that power. The preamble, though part of the Constitution, is neither a source of power nor a limitation upon that power. The preamble sets out the ideological aspirations of the people. The essential features of the great concept set out in the preamble are delineated in the various provisions of the Constitution. It is these specific provisions in the body of the Constitution which determine the type of democracy which the founders of that instrument established. The quality and nature of justice, political, social, and economic, which was their desideratum. The content of liberty of thought and expression which they entrenched in that document, the scope of equality of status and of opportunity which they enshrined in it. These specific provisions enacted in the Constitution alone can determine the basic structure of the Constitution as established. These specific provisions, either separately or in combination, determine the content of the great concept set out in the preamble. It is impossible to spin out any concrete concept or basic structure out of the gossamer concept set out in the preamble. The specific provisions of the Constitution are the stuff from which the basic structure should be woven. Last line, if Your Lordship sees, that law cannot be subject to any other test like the test of free and fair election in an ideal democracy. So, accepting the fact that the constitutional amendment can be tested on basic features, saying that free and fair elections is a part of the basic structure, democracy is a facet of that, but saying you can't test statutes on the basic structure. Then, Manoj, Krishnamurti, it's not in the compilation. Krishnamurti is 2015, 3 SEC 467. This is a situation where a affidavit, which was required under earlier Your Lordship's judgment, had to be filed by the candidate and he had failed to do it or suppressed. The question was whether this amounts to a corrupt practice. This is 2015, 3 SEC 467. I'll just read two paras from it, 12 and 13 now. I'll read particularly para 13, Manoj. Para 13 is at page 480. to answer the said question, it referred to, this is referring to Association for Democratic Reform. It referred to the authorities in Vineet Narayan, Kehoto Holohan, and opined that in case when the act or rules are silent on a particular subject and the authority implementing the same has constitutional or statutory power to implement it, the court can necessarily issue directions or orders on the subject to fill the vacuum or void till the suitable law is enacted. That one of the basic structures of our constitution is republican and democratic form of government, and therefore the superintendence, direction and control of the conduct of all elections to parliament and to the legislature of every state vests in the election commission. And the phrase conduct of elections is held to be of wide amplitude, which would include power to make all necessary provisions for conducting free and fair elections. Both of these judgments then reiterate across a span of nearly 40 years the fact that free and fair elections, democracy, etc. are part of the basic features. It's reiterated in the Scora judgment, that's 2016 5 SCC page 1. Yes.
Part of the issue. It has to be fair and absolutely.
No, this particular para I read because it mentions the election commission's role.
It's correct.
So one is the value. The second is the entity who enforces that value. Independence of judiciary enforced by Supreme Court. Therefore, appointment system becomes important. Free and fair elections, democracy ensured by election commission. Therefore, appointment to the election commission becomes important. I'm sorry if I'm berating, I'm just reiterating that point too often. So I'll stop with that one. Therefore, my submission on the first one is complete. Second, coming back to Article 324. No, I'll give the parasite. Coming back to Article 324 and the question of the protection that has to be given. This is Article 324, subclause 5. If I can trouble your lordship with reading this, because there are two provisos. And the interplay of those provisos is something which I believe is not an argument made in the Session matter. So the observations that Sessions judgment made was only to reconsider the decision in Danoa as to whether the CEC was in any way in a preeminent position over the other election commissioners, or is he on par? The argument made in Session was, look, he is obviously very different because he has the power of recommending the removal of the other election commissioner. The court rejected that and said, yes, there may be a difference here, but on all these other things, you can see parity, including the 1991 Act. Therefore, the CEC and the election commissioners are on par, something that at that time the petitioner, Mr. Session, did not want. Now, taking off from that point, the question now before your lordships, apropos of the first prayer in my writ petition, is the process of removal which applies to the CEC, does that same process of removal apply to the election commission? On first blush, it appears it doesn't. In fact, the judgment in Session, without going into that question, merely recognizes that there is a difference. It doesn't say how it's different, but it says that it's different. The reason, my lords, if your lordship will see 324 subclause
goes on to provide the additional safeguard of declaring the law to be that though they can be removed on the recommendation of the CEC,
yes,
there should exist real, reason.
Reason, absolutely.
So all those have been explained.
Correct.
And the distinction has been sort of cast in stone.
So I'll just cut to the quick and tell you, your lordship, what my argument. My argument is, because of the language employed in 324(5), the additional procedural requirement which is provided in that proviso is that there will be a recommendation from the CEC.
Correct.
You will not remove the subordinate without at least a go by as far as the person in charge is concerned.
Correct.
That's all it does.
Correct.
My interpretation is that the same process of removal is required for both CEC and the EC. Same process. And that, I believe, flows from the language of the provision. If I can read that for you.
Very cautious homicide.
I Yeah, I would say causes omissions would apply in a situation where there might be an ambiguity regarding it. I'll just read this to your lordship and then I will examine Manoj whether there is such an ambiguity. 324(5) says, subject to the provisions of any law made by Parliament, the conditions of service and tenure of office of the election commissioners and the regional of the election commissioners and the regional commissioners shall be such as the president may by rule determine. No model up to here. There's a colon there, after which proviso, first colon, provided that the chief election commissioner shall not be removed from his office except in like manner and on the like grounds as a judge of the Supreme Court, and the conditions of service of the chief election commissioner shall not be varied to his disadvantage after his appointment. I'm pausing for a minute. Two parts here. The CEC can only be impeached, and B, you cannot change his conditions of appointment to his disadvantage. Two parts. Proceeding further, provided further that any other election commissioner or a regional commissioner shall not be removed from office except on the recommendation of the chief election commissioner. Two possible interpretations. One, which is the one which appeared to be the one that they argued in session, is to say chief election commissioner impeachment, election commissioner just show him the door once there's a recommendation from the CEC. So it virtually becomes summary, no procedure, nothing like that. What I'm arguing is the main proviso says two things. It says that the CEC shall not be removed except by process of impeachment, and that his conditions of service shall not be varied to his disadvantage after his appointment. The reason why they mention only the CEC is because the Constitution provides really only the CEC. The EC is at discretion.
If any.
So, if any, absolutely, I'm grateful. It uses the words if any. So, if the EC is not appointed, it would be perhaps superfluous and unnecessary for them to provide separately. But once the EC is there, is there a possibility that when they start the first proviso with two parts, that neither of them will apply to the second proviso? I ask myself this question because if that reading were to be followed, that would mean that the election commissioner's conditions of service could be changed to his disadvantage. You can't do it for boss, but you can do it for subordinate. My interpretation is those two things continue to apply. They will apply to the election commissioners, but with the additional procedural safeguard that you ask boss. Can we proceed against?
Why you are this is question at the moment?
The reason is my prayer in my writ petition is that the same process of removal has to apply to the election commissioners so that they can act independently.
Tell you one thing.
Yes.
Please go through once again.
Yes.
If you will see clause 2,
Yes, sir.
it refers to chief election commissioner and election commissioner.
Yes.
So this mechanism of appointment is covered by clause 2.
Yes. But it says if any as far as election commissioner.
Correct.
Yes.
Now if you come to 4,
Yes.
this deals with the mechanism and if you turn over the page, election commission,
Yes.
accordance with so and so.
Yes.
5 refers to the condition of service of election commissioner.
Yes.
Nothing to do with chief election commissioner.
Yes.
If you see in 5, subject to the provisions of any law made by the parliament,
Yes.
the condition of service and tenure of the election commissioners
Yes.
and the regional commissioners,
Yes, sir.
as per the rule.
Yes.
Now that will determine
Yes.
the mechanism in ousting the election commissioner refers to the further proviso. Second, the first proviso refers to clause 5 is absolutely clear, chief election.
I'm sorry, clause 5 is dealing with conditions of service and tenure of election commissioners and regional commissioners.
Not chief election commissioner.
It doesn't say so.
Yes.
It doesn't say so.
Now it's with the proviso.
No, but the 1991 Act does. It deals with the chief election commissioner.
Proviso, first proviso deals with the ousting of a chief election commissioner.
Yes.
Then second proviso, since the substantive clause 5
Yes.
refers to rules
Yes.
for election commissioners.
Yes.
That's why the second proviso deals with the mechanism under the rules
Yes.
inbuilt for the purpose of ousting him.
But
You're not wrong.
No, but
The chief election commissioner mechanism is different. It is the mandate of the constitution itself interprets independently.
no, the problem is it says conditions of service and tenure.
Condition service covers all.
It should, but since the 1991 Act, which is made under this clause 5, doesn't deal with removal at all.
Yes, for whom? Election commissioners.
Yes, it doesn't deal with removal for anybody. Your lordship may just take that. That's the first volume.
Why you are apprehending at the moment? Ever an incident has come forward before you?
No, no.
Let me ask something. Ever come across any incident ever happened where this
reason
power
why-
available has been misused arbitrarily by any authority?
It's not that, no. It's about, and I'm sure the AG will also support me on this.
AG is not necessary.
No, on the interpretation, on the interpretation.
Okay.
The interpretation of the government at the moment, and which is what the apprehension is as far as we are
Can
concerned.
you, Gopal,
Is-
keep one thing in mind.
Yes,
To see service jurisprudence,
yes, ma'am.
take the order of suspension.
Yes,
The appointing authority holds absolute power
yes,
to place under suspension.
yes,
And he's not supposed to assign reasons also for suspension, contemplation.
yes.
Number of times arguments are advanced before this court that this is an absolute arbitrary discretion vests with authority. And you may call on legal framework is not any kind of a stigmatic, but it's social stigma.
Yes,
Social stigma is there, which the
Yes.
man carry who is under suspension.
yes,
But this court has always come forward
yes,
that merely because the power vests with authority to exercise in a given facts and circumstances, court may struck down the order. But to say that the authority's power vested in exercise under the constitution in the instant case can't be regulated by any election mechanism. Unless we find,
yes,
like you are before us,
yes,
that time has come, the manner in which chief election commissions are working,
yes,
people have different kind of their own perceptions. Now you are taking a call
yes.
to this court to step in and lay down the guidelines.
No, I'll explain what the
Why
problem is.
you have come? You have come.
I'll explain.
You have come here. They look here. What is going on? The ground realities.
I'll explain.
Please step in
No, I'll explain.
and lay down the guidelines
No, Manoj, I'm sorry.
in place so that the people should know what is the mechanism adopted by the government. appointment.
I should have been clearer. This is not like a service matter. This
No,
is
you're right.
because I know the reason why we're here is threefold, and I'll tell you lordship what that is. First, you have a judgment in session where the argument is taken and accepted that the process for removal of the CEC as versus the ECs are different. The process of removal is different. We have that counter affidavit to the election commission and all the correspondence where they say, please ensure that the process of removal of CECs and ECs are put on par. Repeated letters. Even the law commission considers this. The ubiquitous view, and this is why I believe even the AG joins this, is that at the moment, the CEC can be impeached. The ECs can just be removed on a recommendation of the CEC. In fact, that was the argument made by Mr. Session in the Session case, saying that, look, I am preeminent, I can recommend his removal. So I stand differently from him. What we are saying is, once a judgment has come that all of you are on par, and we are trying to protect the entire litigation here before this constitution bench is about protecting the election commission. You can't have a protected election commission if the election commissioners are also not given the same protection from removal that the CEC is given. He's just first among equal. It's like saying that the Chief Justice of India can be impeached, but the judges of the Supreme Court recommended. I'm drawing a parallel. I'm saying these are institutions which require protection. So the offices that are held within that institution require the same protection. He may be first among equals, but he's not different. That's what your lordships have said in session. So here, unless the government has a different view and accepts my interpretation, in which case I have to say nothing else. If your lordships reads 324(5) with the proviso, I'm grateful to Justice Rastogi, the proviso brings the Chief Election Commissioner in. The proviso does, the main provision does. And what does the proviso say? It gives him two protections. It says your process of removal will be the same as that of a judge, and your conditions will not be changed to disadvantage. Surely when the second proviso after that says provided further than what? Further than the proviso which just preceded you with a colon. I keep saying colon because Justice Arun Mishra's judgment in that indoor development places great emphasis on the colon in section 24(2) of the Rehabilitation Act and the importance about where the proviso fits. So I'm saying here you have a colon after 324(5) and you have a colon after the first proviso. So proviso 2 is stitched to proviso 1 and says impeachment conditions not to be changed to your disadvantage, further provided that for you, when you are going to exit, recommendation of CAC is required. That's the way I would interpret it.
Otherwise,
Yeah.
you mean to say that otherwise there is a vacuum in the second proviso.
Yes.
Because the procedure, what should be the procedure for removal?
Yes.
It is not actually specifically
Specified at
stated
all.
in the
I
second.
am most grateful.
Whereas in the first proviso,
Yes,
it's very
it's
specific.
very specific. Either we say it's a vacuum and then that vacuum has to be filled up, which has not been filled up in 72 years. Or there is no vacuum.
If it is a vacuum, then it is to be filled up.
Yes.
Or else the how it should be interpreted.
It will be. I'm most grateful. That perfectly sums up what I'm saying. In fact, I didn't have to waste 20 minutes. That 2 sentences sum it up. The second proviso is stitched to the first proviso. And therefore, the process of removal of the election commissioners has obviously to be on par with that of removing a chief election commissioner, because otherwise the other protection also goes. His conditions can be changed to his disadvantage. It's meaningless because across the constitution for civil servants, UPSC, judges, the elections are given that protection that won't be changed to their disadvantage. How do you suddenly stop at the C's?
Or you can put it the other way around.
Yes.
The second proviso only put a mechanism how to put the things to motion.
Yes.
The process to be initiated by the chief election commissioner.
Yes. On his right.
Thereafter the first proviso to follow.
Correct. Correct. That's exactly. That's also a way of looking. That is when you stitch these two provisos together. That's the only way it could possibly flow.
So the initiation will be by the chief election commissioner.
Yes.
The second proviso is over.
Yes.
Then you fall into the first proviso.
Yes.
And the first proviso mechanism to follow for the purpose
Absolutely.
of taking a final call.
Absolutely. In fact, in a completely different context.
I have examined in one of the matter, I am the author. This colon, Mr. Sibal argued before.
Sorry? Oh, yes.
I am author in that judgment.
Yes, yes.
I examined that colon. I think you are there.
Yes. I use that argument there also. Yes. The rule 4 of the CSE rules, we came up for consideration. The civil service examination rules came up for consideration in a judgment which is 1992. Supplementary 1 SCC 594. It's called Mohan Kumar Singhania. Just one para because it interpreted this phrase provided further, but not in a constitutional context, I must be fair. And it says para 86. I'll just read that para. The submission made by Mrs. Chopra that the second proviso is an independent one does not merit consideration because the second proviso to Rule 4 begins with the words provided further, which expression would mean that a strict compliance of the second proviso is an additional requirement to that of the substantive Rule 4 and the first proviso. The expression provided further spells out that the first proviso cannot be read in isolation or independent of the second proviso, but it must be read in conjunction with the second proviso. To put it in other words, is on the facts. Once the candidates belonging to SC or ST get through one common examination and interview test and are allocated and appointed to a service based on their ranks and performance and brought under the one and same stream category, they too have to be treated among all other regularly and lawfully selected candidates, and there cannot be preferential treatment at that stage.
Your citation again.
This is 1992, supplementary 1 SCC 594 at para 86. This is page 629 of that book. Page 629.
Paragraph? Paragraph?
6? Para 86. 86. Bottom right. Now, I'll just take 5 minutes and wrap up, Manoj. If your lordship will just take one last volume, which is that that counter affidavit of the Election Commission in my petition. It's page 629, 620, 630.
No, the counter affidavit is.
Yes, the counter affidavit of the Election Commission.
Are two.
Yes, please, are two. Wait. Now, this is the Election Commission's own stand here, man. In fact, the Election Commission should be sitting on our side because we are fighting for that.
I follow protocol was corresponding one side, but that's.
My dear friend, Mr.
Even if he wants to come down to your side, yes, certain compulsions.
No, absolutely. I understand that. I understand that.
I'm not saying the Supreme Court, honestly, because there is no side.
What he is saying is on the lighter side. You are not supposed to respond.
He's a dear friend.
He takes it for his petition and certainly he sits on that side.
Mr. Amit Sharma, apart from being a dear friend, is the captain of the cricket team on which I play. And we have a Ranji Trophy player here, Mr. Balbir Singh as well. Lords, if your lordships will see the correspondence that has been set out, I just want to highlight 2 or 3 of them. The first one is at page 45. Sorry, page 21. Page 21.
Which counter?
The counter affidavit of the UGC in my writ petition, in Ashwini Upadhyay writ petition civil 1043 of 2017.
Amit Sharma.
Yes, Amit Sharma. Have that volume. Well, there's a series of correspondences which will start at page 20 onward. I just want to highlight 2 or 3 of them. The first one.
Mr.
Yes.
What do they broadly say? I mean, before you take specifically, what is their
They
stand?
repeatedly say 4 things, Manoj. They say, 1, please ensure that the election commissioners are on par with the chief election commissioner. They say, give us an independent secretariat, allow our draw to be on the consolidated fund without any voting happening. And with reference to appointment, a couple of letters, not all of them, talk about how appointments should be made in an independent fashion. But that obviously they would be a little limited in writing to the government and saying, please ensure that, considering they themselves have been appointed at that point of time. So,
what do you say? The government is not listening to him.
well, the government, it doesn't appear that they have actually, the one thing which seems strange is that this consolidated fund issue, they repeatedly say, we don't understand why we are not being treated on par with the UPSC, the CNAG, the judges of the court, etc. Why we have, our expenses have to be voted on. So that's why I just wanted to show your lordship, just if your lordship would see a few pages, page 41.
In 27 it says, page 27 it says,
27,
only
yes.
to know why it is so. In order to ensure the independence of the election commission and to keep it insulated from external.
I'm most grateful for. So that's the first, that's the proposed electoral reforms for of 1998. Well, you may just see that. Page 27. The bold portion at the bottom of 27. In order to ensure the independence of election commission and to keep it insulated from external pulls and pressures, clause 5 of article 325 of the constitution inter alia provides that CEC shall not be removed from his office except in like manner and on like grounds as a judge of the Supreme Court. However, that clause does not provide similar protection to the election commissioners, and it merely says that they cannot be removed from office except on the recommendation of the CEC. the provision in the opinion of the Election Commission is inadequate and requires an amendment to provide the very same protection and safeguard in the matter of removability of election commissioners from office as is available to the Chief Election Commissioner. Then page 28, Manoj, Independent Secretariat. Independent Secretariat is vital because they say the independence of the Election Commission, upon which the constitution makers laid so much stress in the constitution, would be further strengthened if the Secretariat of the Election Commission, consisting of officers and staff at various levels, is also insulated from the interference of the executive in the matter of their appointments, promotions, etc. And all such functions are exclusively vested in the Election Commission on the lines of Secretariat of Lok Sabha, Rajya Sabha, registries of Supreme Court and High Court, etc. Independent Secretariat is vital to the functioning of the Election Commission as an independent constitutional authority. In fact, the provision of Independent Secretariat to the Election Commission has already been accepted in principle by the Goswami Committee, and the government had in the Constitution's 70th Bill 1990 made a provision also to that effect. That bill was, however, withdrawn in 93 as the government proposed to bring in a more comprehensive bill, which did not come up. Then page 29 is that other prayer which were made. The commission had sent a proposal that the expenditure of the commission should be charged on the Consolidated Fund of India. The government had moved in the 10th Lok Sabha, the Election Commission charging of expenses on the Consolidated Fund Bill 94 with the objective of providing for the salaries, allowances and pension payable to the CEC and the other ECs and the administrative expenses including salaries, allowances and pension of the staff of EC to be expended charged upon the Consolidated Fund of India. Similar provisions already exist in respect to the Supreme Court, CNAG and the UPSC, which are like the Election Commission, independent constitutional bodies. To secure its independent functioning, the Commission is of the opinion that the bill, which lapsed with the dissolution of the 10th Lok Sabha in 1996, needs reconsideration. Now, this was reiterated in 2004, 2010, 2012, 2016. There will also be just dot the page numbers. 2004 is page 21. 2004 is page 21. 2010 is page 32. 2012 is page 39. All of these are to the Prime Minister himself. 2016 is page 61. And finally, the Law Commission report, the 255th report, endorses these it's in the same volume at page 89. This is 2015.
This law commission is before and then there was 2000.
No, so yes, chronologically the Law Commission would be before the last 2016. You're right.
You have referred certain pages before 39. 21 then?
21, then 32. 21 is 2004. 32 is, page 32 is 2010. So the requirement of an independent secretariat and that the expenditure be similar to the ones that are provided for the other constitutional authorities are the other two prayers here. I don't have to expand on it, considering that the same arguments apply. That if it's an independent constitutional authority, it needs the protection and the independence. Well, I'm very, very grateful for a patient hearing.
Shall I make one submission, Milord, in supplement?
Just one thing I wanted to.
I have filed an application.
There is a judgment, just one second. There is a judgment regarding the appointments to the Central Information Commission, Justice Sikri's judgment. 2019, volume 18 SCC, page 246. 2019, volume 18 SCC, page 246. And the last operative para which contains the directions is para 66. If your lordship just sees the operative directions because they are important for transparency in the appointments. It says 60. Para 66, page 274 of this volume.
Without the business.
66.3. At page 274, para 66.3. Likewise,
Search committee.
yes, and likewise, it would be appropriate for the search committee to make the criteria for shortlisting the candidates public. So they have to have a criteria for shortlisting. Very important from the perspective of what your lordship was asking. Why should there not be some criteria for the selection of election commissioners? So there the search committee has to make a criteria, make that criteria public so that it is ensured that shortlisting is done on the basis of objective and rational criteria. Second, then we also expect that information commissioners are appointed from other streams, because what was happening was only civil servants were being appointed. So they said from other streams as mentioned in the Act, and selection is not limited only to government employees, ex-government employee. In this behalf, the respondent shall also take into consideration the following directions given by the court in Union of India versus Namit Sharma. And the directions were, we direct that only persons of eminence in public life with wide knowledge and experience in the fields mentioned in sections 12.5 and 15.5 of the Act be considered for appointment as Information Commissioner and Chief Information Commissioner. We further direct that persons of eminent in public life with wide knowledge and experience in all the fields mentioned in 12.5 and 15.5 of the Act, namely law, science, technology, social science, management, journalism, mass media, or administration and governance, be considered by the committees under 12.3 and 15.3 of the Act for appointment as Chief Information Commissioner and Information Commissioners. We further direct that the committees under section 12.3 and 15.3 of the Act, while making recommendations to the President or to the Governor as the case may be, for appointment of Chief Information Commissioner or Information Commissioners, must mention against the name of each candidate recommended the facts to indicate his eminence in public life, his knowledge in the particular field, and his experience in that particular field, and those facts must be accessible to citizens as part of the right to information under the Act after the appointment is made. So therefore, my lord, the court has laid down that there should be a criteria. The search committee should make that criteria public.
Transparency.
And when you make a selection, you must point out he is eminent in which field of life, etc., etc. So therefore, my lord, I submit that one of the things, apart from directing a general transparency, the preparation of a criteria for selecting the candidate should also be mandatory, and that criteria should be made public. And when you select, you should mention on what criteria has he been selected, whatever is the appointing committee. I am obliged.
Shall I make a very short supplement?
You are referring to whom?
I am, my lord, in IA number 68521/2021, in petition 569/2021. Your lordship may kindly have a look at this interlocutory application, but where I have produced certain materials, including the position in other jurisdictions like UK, Spain, South Africa, etc., etc. And I will make only, my lord, 3 broad submissions. Very brief also, but I will not repeat anything what has already been argued.
Yes.
But I may start with a very short supplement. But what Mr. Shankaranarayanan was rather referring to as vacuum in the constitutional provisions, especially the provision relating to the appointment of the election commission, I would call it rather as a democratic space left by the constitution. Why I am submitting, Lord, I will just clarify that proposition first and then come to the next 2 submissions. First is a propositional argument. But that is, like there is a clear analogy between the appointment of the judges, as we find in 124 and 217 of the Constitution on the one hand,
In this.
and 324 on the other. I will explain that proposition first.
Right.
Shall I continue, Miller?
Yes, go ahead.
Yes. Like 124 and 217 only said, that the president shall appoint. That is to say, the constitutional provisions, both 124 and 217, only said about appointment and not about selection. But that was discussed in first judge's case in 1981, then second judge's case 93, and the third judge's case 1998. Then the question is how this democratic space with respect to selection of judges is filled up. That is a democratic space not carved out in the Constitution. Constitution didn't insist on any particular mode of selection. Then we looked at the question how far the legislature was able to fill it up pragmatically and imaginatively. Likewise, when the legislative dearth was there, but the two judgments came in second judge's case and third judge's case, and latest 2015 judgment in NJSC. This is the position. As regarding election commission, the position is clearer. I would say that there was a mandate to make a legislation where there is a deficit. There is a clear failure on the part of the legislature. When there is a clear failure of the part of the legislature, I would say that this is a situation where, as it has already been indicated, the free and fair election is a basic feature. My submission is that when there is a legislative inaction to make the election free and fair by making an appointment process transparent and objective, then there is a legislative inaction which has perpetuated the breaking of the basic feature of the Constitution. That is to say, by legislative inaction, the basic structure of the Constitution has been damaged. And that is a situation which will call for judicial review. And an activist judiciary in such a situation can necessarily fill up the democratic space left out by the Constitution by appropriate means. So legislation have failed. Justice Krishna Iyer once said, but in Indre Mulgokar, 1978, 3 SEC 339, that how Justice Krishna Iyer conceptualized the court. His lordship, as he then was said, that the court is not an inert abstraction. It is pupil in judicial power. Yes. When we conceptualize the court as pupil in judicial power, and when there is a legislative refusal rather than a failure, that will justify the necessity to fill up that democratic space by appropriate judicial method akin to what was evolved in Vishakha and Vineet Narayan. This is my first propositional submission.
Your next point.
Second submission, but I have attempted to strengthen this submission from point number E in my interlocutory application. That shows the history of attempts, legislative attempts to fill up this democratic space. Well, there were one step was taken in 1990. If your lordships are having my interlocutory application, IA number 6852.
Through the history.
Yes.
We are going to go through the history of what all has been done. We'll go through that.
Correct. I am only indicating then
that it is nothing has come off it.
1990.
Nothing has come off it. That's what you're trying to say. So we have to do.
Yes, exactly. One step was in 1990, then in 2002, then in 2006, then in 2018. But I leave it to your lordship there, then and there. Then like in ground F, para F, I have given but certain materials, literature and studies indicating that there has been a chronic case in India which shows the ECI's bias in favor of the ruling party. I am not reading it. I am only indicating that this has been sufficiently documented by studies in this country that, my lord, this perpetual bias shown by the ECI in favor of the rule, irrespective of the party. This is supported by certain materials, and also one judgment of this honorable court in a case of 2021, which I have indicated in paragraph 19, page 17. That is State of Goa versus Fausia Imtiaz Sheikh,
Yes.
which said, my lord, that the commission has not been often acting independently. Then the most important point which I wanted to place before your lordship, my lord, is certain lessons from other jurisdictions from page 18
Yes.
of my IA. One is United States. My lord, in answer to your lordship's question regarding the State Election Commission's power, but I was just indicating to suggest that, but we have the US model where even that also, my lord, there is a lot of analogy which can be drawn from the situation in India. But unlike India, they have a highly decentralized structure of administration of elections, where the states have complete autonomy for making laws with respect to conducting of election. Now, this I am placing in answer to what your Lordship Justice Rastogi was pointing out during the deliberation. The US case at page 18, I have shown, in many states in the USA, secretaries of the state who are elected members are appointed as the state election commissioners. Page 19. Every state has their own independent administrative agency to manage elections. But I think, my lord, this is a good model, at least as regarding the decentralization part of it, that can be emulated, my lord, or at least thought about. Then, my lord, US elections are governed by HAVA Act of 2000. There's very many of their enactments have fancy names. You know, this is called Help America Vote Act, HAVA 2000. And it said, you know, that as per HAVA, the election assistant commissioner is responsible for voter registration, voting system, etc., etc. That is an independent regulatory agency solely responsible for managing the finance as per the Federal Election Campaign Act 1971. There's the
We'll go
statutory
through
prescription
it. We'll go through your
now.
material. We'll go through your materials.
Yes, ma'am. Coming to, I will just summarize. Last submission. I have also shown the position in Canada at page 20.
Yes.
We have the roots in Canadian model. We were on 16/6/1949 in the Constituent Assembly debates, where there were discussions regarding the Canadian model, then
right.
UK model. The last better model I have shown as Spain and South Africa at pages 21 and 22
Yes.
of my interlocutory application. 21, you lot may please to see in Spain, as per Article 9 of the enactment there, it's a 13-member commission, where, my lord, 8 persons are from judiciary. Lords may kindly have a look at that also. Then South Africa.
We understood that.
Yes. Now, South Africa also, there is a judicial representation. To conclude, this is my submission. Last sentence is like this.
Thank you. Thank you.
Yes. I am only saying that there can be a better model. We are taking models, I mean, illustrations from other jurisdictions.
Thank you. Thank you. Thank you. Yes, Attorney General.
Yeah, please, Your Lordship. Just find the words. Let me try to begin on a very smaller note if possible, before you open up. I know the attorney shall not be seen to be taking a regressive stand on many of these very important issues.
That's right. That's strictly not adversarial. Public investigations.
I thought, let me focus on some broad issues and then try to explain. The march of law from Vineet Narayan onwards, all of which arose in the context of perceived vacuums in law, statute law, or perceived vacuum defects in statute law cannot be invoked in the present case. 2. The prayers, looked at from any angle, ultimately require this court to alter the structure of Article 324(2), add to it, and in that process further requiring the court to take constitutional policy decisions as to what can be added to in Article 324(2), or what can be substituted therein. This the court will not do apart from being a constitutional policy issue to directly amount to a constitutional amendment. So these are the two broad responses to the petition. Now, the attempt made before I read 324(2) and then what happened post session and all that, I asked myself a question. If after the lengthy Constituent Assembly debates, if the Constituent Assembly decided on one particular course of action, it had all those models, the Canadian model and the other models. It had all the other models. And the Parliament chose at that point of time that we will have a model like this, and broadly corresponding to certain other schemes of the provisions of the Constitution, it certainly had in mind the independence of the Election Commission. You can't attribute 324 that there is a complete absence of mind or application of mind to what may happen in future. That's why Ambedkar said even in future this may happen. Therefore, a futuristic vision as to what may happen was also in the mind of the Constituent Assembly debate. So if all those aspects are in the mind of the Constituent Assembly debate, and ultimately they said the President as the authority will appoint, and in case suppose Article 74 was not there in the Constitution, the President will act on whose advice in Council of Ministers? The President will act with his own discretion. Now Bombay will come in today and say President cannot act with discretion. But there is a provision in the Constitution. So how will the President act as far as the President discharge of powers and functions concerned? If Article 74 were not there, then a moot question would arise. The President is left rudderless as to how the President will discharge all these functions. Now, therefore, the argument today is the President, as if there is a vacuum, in 324(2), that the President does not have an appropriate authority who will ensure the independence of the Election Commission, and vesting this power in the executive cannot be treated to be that appropriate body. Therefore, there is a vacuum, and therefore the attempt is therefore to ask the court to imagine a vacuum and then take a position as to how that vacuum can be filled up.
Kindly come to Article
Yes.
316. Kindly come to Article 316 of the.
Yes.
Please read. That relates to the power to appoint members of the Union Public Service Commission.
Sorry. Appointment and term of office of members, that is the Public Service Commission. The chairman and other members of the Public Service Commission shall be appointed in the case of the Union Commission or a joint commission by the President, and in the case of a state commission by the governor of the state.
That's
Then the proviso says what will
how
be the
they can be removed. How they can be removed is also provided.
Correct.
That is as far as the UPSC.
Right.
Now you kindly also come to Article 148, dealing with CAG. We are just posing the question.
I'm extremely thankful for this suggestion. So what was running through my mind while looking at this 316, 148 and 324?
Yeah.
324 takes care. I'm sorry. I'll just read 140.
The question was to be.
Yes.
148, there are other, safeguards.
Yes.
As far as the CAG is concerned, it will be removed only in the manner it's provided.
Right.
As far as the appointment is concerned, it is by the President. There is no other safeguard. Why is it that when the Constituent Assembly debated it and then finally it was approved,
Yes.
they have put in the words subject to any law to be made? This will be the condition. The second question is, supposing 100 years from now,
Your Lordship, please.
you merrily carry on. Let's
Yes.
assume for a moment everything against you. That you have this executive form where the Council of Ministers under the rules of business, the government with the majority has its way, you pick up somebody, Council of Ministers under the rules of business, you pick up some officer.
I understand.
And appoint. So this merrily continued. Now, is that not defeating the very wishes of the founding fathers you are laying store by when you say that all this was debated? So this is also debated, that you will have a law, unlike in the case of CAG and in the case of Public Service Commission. They're just putting it here.
I quite see that. So if looking at a broad brush comparison of 148, 316, 324, coming back to 148 for a minute.
This says president shall be appointed by the president, nothing more. Doesn't contemplate any law.
I find that there's an important distinction between these three provisions. One is that the Constitutional Assembly and then the Constitution is adopted has added one important provision in 324(2), subject to a law that the Parliament may make in future. You don't have that in 148 and 300.
It is not there.
That's right.
That is the
Therefore,
point.
That's right. I'll add what the Constitutional Assembly contemplated by that. It is not at a future point of time. Let me 324(2) and then come back to my propositions. Why is that a law made by Parliament was thought to be necessary in this context? There are a couple of reasons why it can be. We can speculate on that and try to zero in on what would have possibly the most important consideration why it would take. If I read it like this, the Election Commission shall consist of the chief election.
Have you taken any steps in coming out with any kind of a procedure approved by the Parliament under 324(2)? The procedure which has to be come out by under this mandate.
I'm so sorry.
You have not brought any. There is no mechanism with you. You follow your own mechanism.
Let me try to develop my. Shall consist of the Chief Election Commissioner and such number of other election commissioners, if any, as the President may from time to time fix. The authority to fix the number of commissioners was subject to the President's discretion or its wisdom. And the appointment of the Chief Election Commissioner, other election commissioner shall, subject to the provision so and so, be made by the President. Therefore, the two components here, if both the components should have, suppose there was no contemplation of a law to be made by the Parliament, the President for all times to come would have been the only repository of authority to deal with the Election Commission. So if an argument has developed because there is a parliamentary intervention contemplated, what is that Parliament would have intervened, and it could have only for the purpose of enhancing, if in the course of the exercise of power upon by the President, if there is a certain need to address that question, or even independent of any such occasion having arisen, Parliament looks at it. Like certain developments take place in the area of independence of the election commissioner, and events have taken place in the course of a democratic, polity. The Parliament will look at it independent of whether the President has acted wrongly, erroneously, or whatever it is, inefficiently. So there are two reasons why Parliament can intervene. So I asked myself the question: has any one of those reasons which could prompt the Parliament to intervene have occurred? So it is not enough to say that for Parliament has been silent and inactive, etc., etc. Therefore, an mandamus will issue to ask the Parliament to apply its mind, or what would be the best course of action?
We are not being invited to issue a mandamus to Parliament, which we certainly will not accept. What we are actually asked to do is to sort of repeat a Vishaka, meaning that till you make a law, because we can't stop you from making a law. We can't say what we are going to say, or we are invited to say, should not be fingered with by you, by a law made by you.
Right.
It's a legislative power that nobody can take it away from you. Now, all of this is being traced, if you go to the Constitutional Assembly debate, it is being traced to the fundamental fundamental right of each citizen in connection with the right to exercise his franchise.
I quite see it.
Core of democracy. This is a fundamental right involved. Therefore, for the proper, efficient, effective exercise of that power, you need somebody who will properly, fairly supervise. Now, if you find unfairness is writ large and it's not going to be stopped, our powers are sort of being invoked with the
I see that. I see that. Of course, all of us know by now. That
no court can issue a mandamus to Parliament to make a law.
either council would plead for that or the court will respond to it. I know that. But then therefore we've tried to find a very ingenious and a subtle way of introducing an element of persuasion before the court to say that, look here, I'm not asking for this, but by a very indirect process, I'm asking for something else, which in my understanding would ultimately be the same. The conclusion should remain the same. That will be my argument.
Continue on Tuesday.
Tuesday.
Tuesday we continue.
Your Lordship.